Sarah, do you have a disclaimer you'd like to read about the notice that was given of the meeting?
Notice of the July 12, 2017 meeting of the Tennessee Real Estate Commission, including date, time, and location, was posted to the Commission's website on July 7, 2017. Additionally, the agenda for this month's meeting was posted on Friday, July 7, 2017.
Would you call the roll as well?
Gary Boone. Here. Rick Douglas.
Here.
Marsha Franks. Here. Diane Hills. Here. Johnny Horn.
Here.
Austin McMullen.
Here.
Fontaine Taylor. Here. Bobby Wood.
Here.
John Reeves.
Coming.
Hopefully here soon. All right, we have a quorum. The next item on our agenda is the prayer and the pledge. And although I haven't asked him this morning, Brother Horn, would you be willing to lead us in a prayer and lead our pledge?
I'd be disappointed if you didn't.
Thank you.
Let's pray. Father God, we do thank you for this opportunity to assemble here today to face the flag, please. Flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Next item on our agenda is the approval of the agenda, which was circulated before the meeting. Does anybody have any changes or additions they'd like to make? Commissioner Bloom?
Yes, I'd like to see if we couldn't discuss agreed citation. On the street for several months.
I see that we have property management on the agenda at 10:45 as part of our commission discussions.
Okay.
Do we want to add under commission discussions as well the teams and agreed citations?
Yes, sir.
Is that okay?
Yes, sir.
Okay. Any other changes or additions, Commissioner Franks?
I would like to add a discussion about get a report on the executive director search.
Okay.
All right.
I guess we could put that under commission discussions as well.
And also, I would like for us to, we put off, according to the minutes, until this month, the firm reinstatement rules that have gone to the Attorney General's office.
Okay.
And one last thing that I have is, I'd like for us to discuss the broker's license one more time, about the 120 hours that are required.
I don't know, Austin, whether this is the proper time, but I wanted to talk about this. There we go.
Commissioner Taylor, you have an education, or excuse me, a advertising
Yes, I
issue you'd
have
like
a
to
piece of
discuss?
advertising that I got in the mail that I think needs some discussion on.
Okay. Anybody have anything else they want to add to the agenda? Or take off the agenda? We might need to make some room. Okay, so We have the agenda that we received, and we have added to it agreed citations, teams, executive director search, firm reinstatement rules, 120-hour broker license requirement, and advertising. We'll add all of those under commission discussions. How about that? Okay. All right. If there's no objection, then we will adopt the agenda as amended. And our next item on the agenda is approval of minutes from our June 14th, 2017 meeting. Those minutes were circulated by email prior to the meeting. Are there any revisions or changes that anybody has to the minutes?
Motion, we adopt the minutes as circulated.
Okay, second. All right, we have a motion by Commissioner Taylor, seconded by Commissioner Wood to approve the minutes. Commissioner Franks.
I have one question. On page 4, under commission discussions, it says Senate Bill 1217, and there's nothing written there that we discussed. Does that need to be in there, or leave it alone?
All that we discussed that Senate bill, I think, briefly. Sarah, is there anything that we need to put under that, or do we need to take that heading out, or?
Fontaine had some questions on it. We can go back and add some more detail if you prefer, or
What's your preference?
I think we should put in there what 1217 is.
you can put the email conversation that you and I had, kind of the description of what the bill says. Okay.
That'd be good.
Okay.
Sure, I'll get that from you.
All right, are there any other changes to the minutes? Is everybody okay with staff just adding in a sentence that summarizes that we discussed that bill and what the provisions generally of that bill are, and approving the minutes on that basis?
Yes.
Commissioner Taylor, is that okay with you? You made the motion. Okay. So our motion is to adopt the minutes to be revised by staff to add summary of Senate Bill 1217, and that we discuss that. Any additional discussion? All right, let's vote. All in favor of the motion, vote aye. Aye. All opposed, vote no. All right, that motion passes unanimously. All right, the next item on our agenda is medical waiver request. And it looks like the first one that we have on our agenda is Philolome Liness. I hope I said that close to correct.
Well, they're not here, so they don't
not
have
here.
to.
Okay.
They don't have to be present, but her name is actually Liness Philolome.
Okay,
So it's backwards.
gotcha. Okay.
And so under the rule, they're required to submit a statement of their illness and a doctor's note. Hers is on an iPad. I don't have the page number, but she asked for, her license expired in February, and she's asking for us to waive the late fees. She was having seizures, and her doctor did provide a note that she was having some medical issues.
I have a few questions about that.
Okay. Commissioner Franks?
So I need to know what amount of money are we talking about, first of all?
February. So it'll be a $50 late fee plus $50 for each month that she's been expired.
So about $250, plus or minus $50.
Okay, right around there.
And I'd like to know if she's had any other citations or anything on her record in addition.
We can double check that.
Sarah, what is the standard that we're supposed to apply? So somebody is late, they request a waiver of fees, they provide a doctor's note. How are we supposed to make our decision?
Solely on their discretion at that point.
Okay.
They just have to provide a statement of their medical issues and a doctor's note. Under, I believe it's 1260.01.21. It's on page 7.
Oh, excuse me, I want to, it said be placed on the July 12th 13 agenda. July 12, 13, and that,
I think that meant 12th through 13th, which would be today and
okay, all
tomorrow.
right, thank you.
And I also, I had questions to ask this lady. Without her being here, I can't do that. There wasn't a lot of information given to us other than just the letter.
You can ask her for more information, but under the medical waiver, they're not required to be in front of you.
So this is a license that expired in February?
Yes.
Is that right? Okay.
Be arbitrary on our behalf if we just went ahead and gave her one without more information. Because seizures is a major thing, don't get me wrong, but February to July is several months, and I can't imagine that she would totally be incapacitated during all of that time that she couldn't send in her license.
There's other questions like, was she also employed anywhere else? I have a sister who has seizures, so I understand and I'm very sympathetic about this. But I also know she has many more good days than she has bad days. So I agree that this is incomplete, and to make take a vote on this at this time, I'm just not prepared to do that.
So can we come up with some additional questions you have for her, and we'll have staff reach out, and then we can represent it in August?
I know one question was, Commissioner Franks wanted to know, had there been any other discipline or issues with licensure, is that right?
Yes.
Did you have one?
Yes, it's not the rule that if somebody doesn't renew in a timely manner, they have to get some kind of medical notice, and we have the medical notice. I don't know what would help us if she came before us. She has done everything we asked her to do in our manual.
Wish to make a motion?
Yes, that we approve her request.
I'll second that. All right, we've got a motion and a second to approve the request from Ms. Philoam. I think I'm saying that right. To waive late fees, is that correct, for her renewal?
Yes. Late fees only.
Okay. All right, you've heard the motion. Is there any additional discussion about the motion? Commissioner Taylor?
I just still think it's arbitrary, because if this is the case that all you have to have is a letter from your doctor, it's not complete. There are a lot of people, I can call up my doctor and get, well, maybe, if he answered the call, I could get something in writing to say that I had asthma. Okay. Which I do have. I just don't think this is enough information to make a decision, and it's not me making that noise.
How about this time? Okay. Additional discussion? Commissioner Hills.
I just have a question. So, in waiving late fees, because once you waive the late fees, that way the licensee has the opportunity then to decide to pay the late fees or not, so that right now they're delinquent, or they do not have an active license, correct?
Yes, in this situation, she has not paid the late fees. Now, like on the last one, he was already paid, so he could go back to work, and he wants a refund. So yeah, but she has not paid the late fees at this point.
And is she an affiliate or a broker?
I believe she's an affiliate.
All right, Commissioner Horn? Push that button that says speak, or pull that microphone down a little closer. There you go. It's about there.
just a little bit concerned. The book spelled out what she should do. That's what she did. And for us to attack additional things to me, I can't see it, right? If we feel that there is some additional information needed, then we need to address that. And if we cut it a little bit short, so be it. We just got to live with it until that can be fixed.
All right, any additional discussion or questions? Commissioner Wood?
My thought, the thing I don't like about it is that she's not gone ahead and, I guess, paid the fees. And I always thought that the purpose was they pay it and then they come back and say, hey, can you waive these fees? But by the fact that she's not paid to get her license, we're really not waiving it. I mean, and by the fact that it's come up for another meeting, now it's just another $50. I don't have a problem with the concept of helping people if there's a real need there, but at some point you can help yourself too.
That's direction, not direction.
And the biggest problem to me is I don't know if she's had any other complaints filed against her or any kind of citations.
And there's a little part of me that feels your way, but I really don't know that should matter. I mean, this is a medical issue. It's not how ethical or whatever you are, real estate agent. So I think those probably should be two different points.
I would suggest we change the rule if we don't like the rule, but she matches the requirements in the rule.
All right, well, you've heard the motion. Could we have a roll call vote on this? Yep. Sarah, could you call the roll, please?
John Grease.
Pass.
Gary Bloom.
Yes.
Rick Douglas.
Yes.
Marcia Franks. No. Diane Mills.
Yes.
Johnny Horton.
Yes.
Austin McMullen.
Yes.
Fontaine Taylor.
No.
Bobby Wood.
Yes. Mr. Grease, are you still wanting to maintain your pass?
Yeah, I was
Okay.
present for the entire discussion.
Okay. The motion passes on what I believe was a 6 yes, 2 no, 1 abstention basis. All right, our next item is, sure, go ahead.
Commissioners, I'm sorry for being late. I apologize for that. I'm glad Austin picked up the ball and ran with it. I do want to, I know you guys have approved the minutes of the previous meeting, but there's an item within those minutes that I think we ought to discuss, and I would like to entertain a motion from one of you people who voted to approve the minutes to make a motion to reconsider.
So moved.
Motion by Ms. McMullen, is there a second? The second by Ms. Franks. Now is there discussion on the motion to reconsider the minutes, approval of the minutes? If not, let's vote on that. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. If you all would go to the minutes on your tablet. Second minutes, I got them. Go to page 4 of 17, those minutes. You may recall we had a discussion last month that had to do with people with broker's licenses who, before they completed their required education, decided to drop back to an affiliate broker's license status. And it was alleged that some of those people then subsequently would reapply for their broker's license again, and they still haven't done any education toward the 120-hour requirement. So I asked through an intermediary for Austin to make an effort to reduce to writing what the interpretation of this commission was last month regarding that particular topic. And that interpretation was codified, and you can see it at the bottom of page 4 and the top of page 5.
Since we did this, we've caught the attention of certain people in the legal department here at the Department of Commerce and Insurance, and apparently we've caught the attention of at least one legislator. And so I think both Mark Green and Carter Lawrence are here today to talk about this issue a little bit. I've assured Carter that our intent was not to be punitive, but to at least give direction to staff on how we think it should be handled. But they have concerns they'd like to address to this commission at this point. And I'm not sure who would like to go first, gentlemen. But
Mark, feel free to hop in at any point. And John, thanks for letting me come back down to speak to all of you all. And sorry that we were late. I wasn't aware of this before it came up, and sorry that this flew by my radar for a little bit, but when it did make it onto my radar, I wanted to step in to address this because I thought that, as John said, the interpretation that was made didn't fit with the statute and was also very punitive and potentially problematic for a handful of reasons, including what John mentioned, that potentially drawing the ire of the legislature. The permanent ban on someone coming back to reapply and retest as a broker is, to my understanding, a more punitive measure than anything else that's imposed on licensees for anything else. So that even if someone were to have a revocation of license, they'd be able to come back within 5 years and petition the commission for reissuance of the license. In this instance, though, the original interpretation as made last week was that there would be a permanent bar, and as I think you can understand, it would be problematic. So certainly understand the desire to look at what was presented as a problem, but I would counter with a couple things. First, that the statute doesn't lend itself towards the discussion of what happened last week. And then secondly, after speaking with TREC staff, discovering that there was a little bit less of a problem than we thought there was with folks dropping down their broker's license and then trying to subsequently come back, so essentially gaming the system, if you will. And Melissa is back here and she can step in with specific information, but yesterday I had asked her to try and quantify the numbers, and we're talking about roughly 50 people a year who will drop down their broker's license. Of those, Melissa indicated that she thought that the vast majority were for legitimate reasons where they didn't have the money or the time resources to continue as brokers. There's a specific example, and I won't mention names, but where a legislator has gotten involved because he has a constituent who in 2007 became a broker. The subsequent year decided that being a broker wasn't right for him, dropped back down. 9 years later was trying to come back as a broker again and was told, in light of last month's discussion, no, you cannot be a broker. So that was obviously problematic for the legislator, problematic for me, and I think legal agrees that the understanding of the 120-hour requirement is that within that someone's got 3 years to get those done during that license cycle, and if they don't get them done, they've got to drop down, they've got to retest, they've got to pay the application all over again. So I spoke for a while. Mark, you can hop in, or if any questions from you, the commission.
If I could speak to the statute specifically, the statute, in my opinion, does not preclude someone from applying again. What the statute does state is you've got 3 years to get 120 hours. And if you don't do that, you still, if you drop back to an affiliate broker, you still have to retest and reapply and get 120 hours in order to gain that broker's license. Now, you know, if there's a concern as far as people gaming the system, we could, you know, look at separate different issues, and you know, as Carter said, to the extent that it's going on, we don't think it's rampant or anything like Carter was explaining. But I just don't think there's a preclusion from somebody reapplying and retesting. But the clock is reset. You have to get 120 hours from that reapplication and retesting.
Mark, you could see a scenario where somebody could be a broker, not a broker, be a broker, not a broker, and never take that 120-hour requirement.
Correct.
So I think that was the intention of the commission, was to try to figure out how to address that situation.
I'm not for sure that that's a extensive issue that people are doing. I think the fact that they have to retest and reapply, if they want to continue to have to do that every 3 years, I mean, I think that's a fairly high burden to have to go through.
In fact, Melissa indicated that, to her knowledge, there's never been anyone who has dropped down twice. That they've had people drop down one time and come back to be a broker, but that, to her knowledge, during every single subsequent time as a broker, they've completed the requisite hours. So although there is that theoretical threshold where someone could indefinitely attempt to do that, because of the burden that's imposed on them with the continual retaking, retesting, paying the higher application fee, it has not happened.
Would would it be a potentially correct application or interpretation of the statute to say that you got to complete 120 hours within 3 years of when you first get your broker's license? If you haven't done that, then you can drop back down to being an affiliate as long as you meet whatever the requirements are for. And that if subsequently you then want to become a broker again, you have to complete the 120 hours before you become a broker the second time. Would that be an acceptable interpretation of the statute?
So we don't think that the statute would support that right now. That would require a change in order to get to that point. And I can understand where, from a theoretical standpoint, you might want to get there. As it stands right now, that's not supported by the statute.
So what's the interpretation that you all are suggesting as the one that we should?
Issuance of an original license is issued. Each time it's issued, it's an original license, and you have 120 hours to complete the CEs. No, I'm sorry. 3 years to complete the 120 hours. It's not the same license. It may have the same number, but it's not the same. I think the legislature intended for you within 3 years to get your 120 hours, but it didn't preclude if something comes up and you have to drop back down and you didn't complete those 120 hours, reapplying and retesting, getting a new license, and then taking completing 120 hours.
My recollection of our meeting last month, though, was that we were told that there is just one license, that it's not a new original license.
It's from an administrative function, it's not by law.
That's just the way that we track it, where we assign a single license, and if someone were to retire, it would come back. But that is a bureaucratic fiction, if you will, insofar as we are assigning the same number, but it doesn't necessarily have to be. And I would add, Fontaine, that noise is not from me either. We too are innocent.
I'm just saying that was what I think we were told, or at least that was my recollection of what we were told last month, was that and maybe that was wrong, and it's fine if it's wrong, we want to get the right information, but just that was the information I think we were given last month.
Yeah, I think after looking into it further, what we're telling you now is correct, and so we're correcting the information given last month.
But you're saying it would not be consistent with the statute to require a person, before they went back to being a broker a second time, to require them to complete the 120 hours before they...
That's correct. It would not be consistent with the statute.
Because I thought that would be a fair kind of take into account the risk of people gaming the system, and it would prevent that, but it would also not have the harshness of saying you can never come back.
Well, I would say from a fairness, to talk about this actual example that we have right now of the gentleman who in 2008 dropped his broker's license down to affiliate, so for 9 years he has not been a broker. So he's essentially coming into it new for the first time as a broker. That 120-hour requirement placed on this individual, where he has to get 120 hours up front, is a harsher penalty than the person who's coming to get it for the first time. So we're putting 120 extra hours on the individual who for whatever reason 9 years ago had dropped down versus someone who's coming in for the first time. So it's a disparate treatment in this instance.
Thanks. I think where my problem with this, and I also asked that this discussion be added to our agenda, and we put it under our discussions. But I guess my biggest concern is for principal brokers. That's where the problem comes in, because you can do exactly like I did. I got my broker's license, and I opened my company 2 days later. I had none of the 120 hours. It was very difficult, having never been a broker, only going through the broker management class. But here I am 30 years later. I think my concern is, you can look at our numbers. There are fewer and fewer, and every month there are fewer and fewer people applying for brokers. And because the responsibility has gotten so big for principal brokers, most people are not getting a broker's license just to have a broker's license. It's if they're going to move up to be a principal broker. So I've got a sheet, Carter. I gave it to Sarah for you, my notes from the Orwello meeting. And one of the things that I'm learning from that is what other states are doing, especially with principal brokers. Texas has raised the amount of hours to be a principal broker to 800 hours. Now, they have the most CE requirement in the United States. An affiliate has to have 240. But they only have enough cases in the whole state of Texas to have commission meetings quarterly that last about 2 hours. So education does help. Now, I know statute doesn't allow us to change that education. My question on this subject, though, is this. Do we have the authority to make a rule that would require a principal broker to have more education? Because that's not in statute.
So I'll defer to legal on the procedure of that rule. I would, though, push back on the increase of the education altogether. So take this 120 hours, that it has to be completed within the 3 years. So if someone on day one can go in and can practice without any of the education, then why are we saying that they're going to need, by the end of it, an additional, how many hours did you say for Texas? Did you say 800? So an additional 680, is my math right? Okay. An additional 680 by the end of it, but because the threshold is evidently low enough that someone can just go into it right away, and that they need to catch up over the course of those 3 years. And I don't think that as it currently stands, and then in addition to that the legislative appetite is such that we're going to want to add 680 additional hours requirement because of the concern over barriers to entry.
And I'm not suggesting that. I'm just, what my idea was, and some of the other states are doing it now, is say you get a broker's license, but if you want to be a principal broker, could we ask that the 120 hours come before they are a principal broker? Can we make a rule?
I think that would have to be a statutory change, but
Could we look into that and get back to you to have a firm answer one way or the other?
Because I think this whole discussion is about principal brokers, because Anybody comes in here, the principal brokers with them, and so they are subject to more scrutiny than just a broker.
Yeah, and I take your point, and I think I was kind of going down the wrong track, not where you were necessarily meaning to go. So if it's okay, we'll look into that and report back to you.
Okay.
Basically saying, I'm sorry. This is kind of my two, I think we got two issues is the way I'm looking at this. First of all, I mean, my first issue is, what does the word original mean? Okay? Because that's what the statute says is original. And as I look at it as an adjective, and it says present or existing from the beginning, first or earliest. I don't think that terminology allows us to keep changing the original. Original was the first one. Okay, so I'm not an advocate of that the original keeps getting changed and people keep to get resetting original. Okay, so that's my first issue. And then my second issue is, basically whenever the rules were made, was we said, we'll let you be a broker, but under the premise, we're going to trust you that you're going to get your 120 hours in before it's time to renew. We trust you. And the problem is, there's people that we trusted, and they didn't do it. And now they're coming back and going, you remember you trusted me before? Well, trust me again. I promise I'll get it this time. And that's the problem. Why should we extend that trust to those same people again? They didn't do it the first time. I mean, I think Mr. McMullen's interpretation of the law is probably a whole lot closer than the other one that I've heard here today. And I think his interpretation would kind of take care of this issue, and it would take care of the issue that was brought by the legislator about the person that didn't get their broker's license, wouldn't renew it in a certain number of years. I mean, I think yours would take care of that issue.
Meaning that they had to get the 120 before they could retest, or get a broker.
I mean, we trusted them, and we're expecting them to fulfill that trust that we gave them. I mean, if I could wave a magic wand and do it all over, I'd say you got to have the 120 hours before you can sit for the test. But that's a different subject for a different day.
And are you talking about the second test?
I'm thinking of the very first one.
And that would cure the problem, but that's not what the statute says. So, but I agree with that.
Magic wand.
I agree with that. I do agree with that.
But
So if
the thing
you're
that you
coming
did.
the second time, if you're coming the second time before you test for the second time, could we have a rule that says get your 120 and you can retest?
Because you had acted all that time.
But see, the thing that got, when your case, Marsha, when you became a broker, the pressure on you was you had to get that hours in, otherwise you were going to be with a broker in a certain time period. But you didn't misinterpret what the word original meant. And you just have to understand you're going to be closed or without a broker. And none of us realized there could be some gaming involved, and that's kind of what we got here. So.
It was shocking to us when we even heard the concept.
Okay, so let me just procedurally make a suggestion or two. So the minutes, first of all, there's a motion that was approved to reconsider these minutes. If you all agree that the minutes accurately reflect what happened at last month's meeting, we'll take a vote to approve the minutes again. Then I was inclined to accept a motion to amend the agenda to add this item back on for discussion, but Ms. Frank says it's already on. So we're going to discuss it. Is that so? We don't have to do that. There may be, and I think it'd be appropriate after we vote on approval of the minutes, to somebody amend the agenda to move the topic up to next, so we can keep these gentlemen here and eventually something. So that's kind of how I see it playing out. Is there a discussion on that?
I don't really care whether we do it as an amendment to the minutes to say that this is what we decided last month, or we do it to say this is what we're doing this month. It's going to come out the same result either way.
It's like a paper trail from my perspective.
So you could withdraw your motion too.
I think John's motion was intended, and I don't want to put words in your mouth, but was intended to say that the minutes didn't accurately reflect what we did last month.
No, the vote, if you think that it does accurately reflect what we did last month, then you'll vote yes when we approve the minutes here in a minute. But there appears to be reason for us to discuss it further on today's agenda, and that's why I would like to have, that way we'll have a paper trail showing how this worked.
I move to approve the minutes as submitted.
We made a change.
Except for on page 4, the Senate Bill 1217, we wanted some verbiage in there for that discussion.
We've already done that.
Well, but then we voted to reconsider, so we're back.
It's a parliamentary procedure. Is there further discussion on the motion to approve the minutes?
There wasn't a second, I don't think.
I think Mike wants to say something. Oh, I thought you did.
I'll second.
Okay, the motion by Ms. Frank, seconded by Mr. McMullen, that the minutes be approved as amended and further as submitted. If you're in favor of that motion, vote aye. If you're opposed, vote no. That motion passes unanimously. Now,
See what happens when you don't get here on time.
no, I know. I'm going to give it back to you in a minute, but I want to get, this is part of the reason I wasn't here on time.
I understand. No, I'm just messing with you. Okay.
Sorry, no, is there?
I'd like to make a motion that we move to this point now, the discussion that we were going to have about CE for brokers.
Is to caption it correctly, it'll be broker 120/62-13-303H. That's the topic. We've already had discussion on it. Is there further discussion or a motion to get this thing kicked off? The motion, a proper motion might be to confirm what we did last month, to change what we did last month, to delete what we did last month. Any of those are options.
Can I make a comment?
Absolutely.
I've been put in a box here of having to choose between two options that I don't like either one of them. I don't like saying that somebody can keep coming back as a broker and being a broker for 3 years without getting the 120 hours. I don't think that's fair to the public to have people out working as brokers who are not getting the 120 hours that they're supposed to get. But the other extreme is we're being told the other potential interpretation, the one we adopted last month, was a very harsh rule to say that if you don't get the education within 3 years, tough, you can never be a broker again. I don't like that option either. I think one is far too lenient as far as protection of the public, and I think the other one is too harsh, taking the example of the person that you're talking about who came back 10 years later and said, gosh, I tried this 10 years ago, it didn't work out. I'm in a different place now, I'm ready to go, and probably will be a great broker. I would like to see us adopt an interpretation that allows somebody like that to come back and be a broker if they get their 120 hours. But you're telling me that there's no way to get there under the statute, which I thought that was something that could be done in conversations that I had subsequent to our meeting last month. But now you're saying that that's not something that can be done.
That's right. And if I could respond to that, that on the one hand, we have the theoretical harm of someone gaming the system and continually avoiding their 120-hour requirement by dropping down every 2 years, 364 days, and forever avoiding it. Our understanding from TREC staff, however, is that that is not happening, and to the best of our knowledge, has not happened, where someone has continually avoided. We do know that people have dropped down before and have come back to be brokers, and during that subsequent time have gotten their requisite hours of continuing education. Right. So we do have that theoretical problem where that could happen, and where there's potential harm to the public of someone holding out without getting knowledge. On the other hand, we see the very real harm that has happened where someone is potentially barred from ever being a broker again because of a decision made 9 years ago that wasn't something criminal or not a bad actor. So between those two, between the theoretical and the practical, I think that the interpretation where we are consistent with the statute and then also not harming people's ability to work and then also not drawing the ire of the legislature is the preferable interpretation here.
Why were we presented last month with this as an issue at all? because it was brought to us, and I was under the impression that this was a problem. And it was brought to us and represented that it was a problem of people gaming the system and that we needed to have an official interpretation on this. That was what we were told last month.
I've got a little history on that. I was at the PSI meeting. I was the only commission member at the PSI meeting where we went over the exam and changed the exam, those kind of things. There were 3 other licensees there. I heard them discussing, they were naming people who were doing this over and over and over. And I'm like, what? And so I asked that question in Collierville, and the only person who had an answer was, what's her name, the little girl, was, what's her name? Brooke. Brooke said, yes, that happens all the time. And so I said, well, we need to follow up on this and we need to figure this out. That's where it came from, because none of us had heard anything about it, and when I brought it to the attention of the commission, we knew something wasn't jiving with all of this and we needed to do something about it. It comes down to, I really feel like we need to be proactive, not reactive to a lot of things. And if this is something that we can improve on, whether it be by rule or some other way, I'm for that. If you're telling me, though, that statute says we have no choice, then we have no choice. That's what I'm hearing. Is that correct?
That's right. I mean, you certainly try a legislative proposal, go to the industry to try and change the statute on it. But I apologize that Brooke gave you that information when Melissa has had information to the contrary about this, and I can't speak to why she presented that as a big issue to you. And I understand and appreciate the desire to be proactive. It's just it appears not to be the case.
I would think that somewhere it could be a rule, because I had one licensee, never heard of it before, but it happened. PSI, they told her to go have her finger to. She did before she came to the broker and send that in. And so when she came to the broker, said, you need to go be fingerprinted. She said, I've already done that. That's been sent to the state. And I said, what? Been sent to the state. So here it was to the state, and we're sending the information to the state. I thought, this isn't going to work. So we sent the paperwork to the state. Two separate things. So when it came, so we had to come to the state to get married and find each other. When they came here to get married, before she could get her license, she had to take 30 hours as a new licensee. And those were the hours she was supposed to take after she is issued her license. So that's sort of what we're talking about, is taking the hours. So she was required to take the hours that she would normally be taking after she's issued her license. She was required to take those hours before she could ever be issued her license. So it would be the same thing with the broker, so why couldn't we do that?
I'm not sure the specifics of that, and looking back to see if staff remembers that specific case. My assumption is that was a misapplication of the relevant rules, because in this instance, a rule would not be able to impact the statute. So that's why for here, and I can't speak to that other instance, but here at least, we are bound by the statute and not by rule.
Do you two agree the commission has some ability to interpret statute?
Yes.
And that's what we attempted to do here.
Yes.
There was nothing wrong with that effort. You're just saying our interpretation is incorrect?
I'd probably say it more diplomatically, or
That was how
reconsider.
Where would you say that? Okay, what would you say?
I would say that there is another interpretation that is less harsh than the interpretation.
Modified our interpretation to make it less harsh, you wouldn't be down here holding this at this point?
I would never scold anybody on the commission.
May I ask a question?
Absolutely.
Get some clarification. I think there's been so much made of the word original here. It appears to me, and you can please educate me on this, it appears that the word original was used so that we can say it's a cumulative number of hours from the time that you got your original license, okay, of 120, okay, as opposed to when you applied and took the broker's test, now you're starting at ground zero to get 120. That was the whole purpose for using the word original, is that correct? That's right. Okay.
So that's what Mark, what you said earlier about the clock resetting. This is someone could have done some hours already. Someone could have done 20, 50, 100 hours, but the clock is reset, and they're going to have to do all of those before their renewal.
They're going to start over.
Within 3 years, they're going to have to do it.
I'm having a problem with that too, because now you're letting them reset after the three years. My interpretation of original is it's the first only one time. There's only one original thing. That's it. It should start at the first time they took the broker's license. They have 3 years from that first sitting to get their 120 hours, and then they have to go back and start.
So to clarify this, the person who in 2007 became a broker and then voluntarily dropped down, you're saying that person would never have the shot at being a broker again. That's what you support?
That's not what I said. I said they had the 3 years. They can't just automatically reset every 3 years. That's what what I'm hearing from you all, is you're saying that every 3 years they can reset and take the 120 hours.
It would be required.
And 3 brokers all during that time are resetting. That's where I have the issue. If you don't do the 3 hours within the first 3 years, then you're not a broker. You have to reset for everything, test everything, and start over.
Yeah, that's what we're saying. You have to do the test and you reapply.
But you cannot be a broker until you do that.
No, currently, as it stands right now, the 120 hours are not required as a prerequisite of licensure. So those 120 hours are obtained over the course of 3 years. So we're saying that it's the exact same. If I were to, for the very first time, meet the other prerequisites, become a broker, I would have 3 hours. I would have 3 years to get the 120 hours. I am in the same position as the example that we gave earlier of the person who in 2008 dropped their license down and is trying to come back as a broker again. Both of us have had to apply, meet the other prerequisites, apply, pass the test, and that we both have 3 years to get the necessary hours.
Now, give a scenario here and tell me if I'm right about this scenario. On this word original again, let's say I'm an affiliate. I've got 90 hours. I apply and take the broker's test. Okay? From the date of my original affiliate license, okay, I've got 90 hours. Now I have 3 years to complete the additional 50 hours to equal 120. That's the way I interpret this. Is that not right?
So we're talking about
that's the reason I thought they used the word original here, is from the date of it. If you read it here, it says, if a licensee with a broker's license has not completed 120 hours of continuing education within 3 years, okay, from the date of issuance of the original broker's license.
That 120 is in addition to whatever
In addition to whatever
as an affiliate.
Okay. All right.
What if it would be that they weren't allowed a principal broker's license until after the completion of the 120 hours the second go-round.
That's what I was.
That's what we're all, I think, trying to get at.
That's the...
Is the harm to the public mostly comes from a principal broker than a broker, because a broker really has no other additional things than an affiliate does, really.
Well, I don't do define principal broker.
On the license,
That's-
it
On a
is.
license,
I know that doesn't, but statutorily, is there a difference?
I know.
I don't think there is. I think it just gets printed on the license. Because you have to have one.
We had the word.
All right, so the chair's in the mood to entertain a motion.
I'd like to make a motion.
Go ahead, Mr. McMullen.
I move that we revoke the interpretation that we adopted on this statute in June 2017.
Second.
Okay, we have that motion on the floor, properly seconded by Ms. Franks. Before we vote, I'll ask legal, is it possible that you guys could bring us an interpretation that you all would be satisfied with for us to consider to approve at a subsequent meeting?
That's fine with me. To clarify, what we just discussed right now, you would like to see that in writing? Is that what you're requesting?
Staff, let's just talk about staff for a minute. So they come to us last month and say, we don't know what to do in a situation like this. Give us some direction. So we tried to give them direction with this interpretation. There's a motion now to take that interpretation off the table. But I still think it would be helpful to staff, it would be helpful to licensees and the public to know what happens in a situation like this. So if there's a more palatable interpretation that we can at least have codified somewhere or another, whether it's an interpretation or rule, I don't care, it would be helpful, I think. And maybe you want to tell us that the way it's written is just perfect. And if that's okay, I mean, tell us that too. But I think the effort of everyone's commission is aimed in the right direction, is trying to give direction to staff and also to licensees about what they can and can't do.
We certainly can come back with a written explanation of what we've talked about today. As far as the practical implementation, I would say that the way that we've previously dealt with the issue of people resetting, of people dropping down their license is the correct interpretation of the statute, where someone, when they come back, they have to reapply, they have to retest, and that they've got their 3 years to complete the 120 hours.
The direction to staff would be anyone that wants to retest and reapply should be allowed to.
Yes, they're allowed. We would approve them to continue with that.
So do we really need any extra, do we need them next month to just restate that?
Well, I don't know if staff has written direction.
Right now, they basically are on, they're basically, they were explaining to everyone last month's interpretation.
And when I found out about it, I asked them to hold off, that I wanted to speak with the commissioners, explain concerns, talk about the statute. And so anytime someone asked, the example that I gave earlier, for example, that real person, to hold off and that we were going to come back to them.
I guess my sense is, at some point, I'd like to have in the minutes what the proper interpretation is, so the staff, when somebody questions them, can point to the minutes of August 2017 and say, this is how the commission looks at it. And it may be exactly how you guys have just stated it, but at least we'd have it recorded in the minutes.
I'll draft a statement.
That's perfect.
In the meantime, though, because of the potential harm to brokers, I believe that we should continue with the traditional practice of approving the individuals to come back and reapply, retest, and continue.
I think that will be, if Mr. McMullen's motion passes, that's where we'll be.
Right.
I just think if somebody's reading our minutes 3 or 4 months at a time, they might like to see how we resolve it.
Sure.
Okay?
But I would also like to add, if there's any way, Mark, that you could help us or give us direction on solutions to that problem too, if there aren't any, that would be great too.
I'll be happy to.
We've already wasted too much time on something that we now know is not an issue at all.
Further discussion. Let's vote on Mr. McMullen's motion. If you're in favor of rescinding our previous interpretation, you vote aye. If you're opposed, vote no. That motion passes unanimously. Thank you, gentlemen, for the discussion. Thanks, Commission, for your thoughtful discussion as well. Before we take a break, I've also, Mark, I'm going to go to Carter for a second. I've asked Carter to give the commission an update on the executive director search. We'll take a break following that. Carter.
That was also an item that I added to the agenda.
Well, so yeah, I'll try everything all together. I promise.
Thank you, Chairman. So we're in the process, as I believe communicated with all of you. The job posting and description was posted across multiple formats, both internally and externally. We had quite a few applicants that the Chairman and I are in the process of reviewing and reaching out to schedule interviews with. So we're excited about both the quality and the quantity of the candidates that we've had reach out to us, and hope our intent is to, by the next board meeting, be able to make a presentation to y'all on the as to recommendation.
So that resume deadline has passed now?
It did, yes. It was last Friday? Yeah, it was last Friday.
Okay.
So it was, we accepted resumes for about 3 weeks.
Told that the posting had been approved and had been sent out?
I emailed it to all of you ahead of time. But before, I emailed it to all of you but prior to posting.
Just one follow-up. In my opinion, we had 36 resumes, just to give you some sense of the... Other questions about that, we'll try to keep you informed as we can, but hopefully by this time next month, we'll have a candidate to recommend to you all. If not, let's take a 10-minute break and we'll get back to work.
Thanks.
Here. Okay. Could you all come to the front and have a seat in these two chairs over here? That'll be fine.
We'll stand up really quick and raise your right hand.
Yeah, stand up and raise your hand. She's going to give you an oath.
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Perfect.
Introduce this matter.
Yes, Ms. Pearson has taken and passed the Tennessee real estate exam for an affiliate broker, and it looks like Ms. Pearson pled guilty to charges of petty larceny. This is a misdemeanor, but it involves the misdemeanor of theft of services, property, or money. So she has to come before the commission.
Okay. Thank you for being here. The way we usually do this is we give you an opportunity to, Ms. Pearson, to explain to us anything that you would like for us to know or understand about your conviction, the circumstances of the crime that you committed, anything else that you would like for us to know about what you've been doing since that time, why you want to become a real estate broker, etc. After you've had an opportunity to explain all that to us, we may have some questions. And then after that, Mr. Massengill, we will let you tell us anything that you would like to tell us about your practice or why you want to hire Ms. Pearson. We may then have some questions for you, and at that point, we will probably move forward with discussing it and making a decision. Okay? So, Ms. Pearson, at this time, I'm going to turn it over to you, and you can tell us. And when you talk, if you would, just pull that microphone over there in front of you, and as long as the red light is on up on there, it is catching you. If it doesn't come on, you might want to touch it or hit the speak button that's down at the bottom, and that way they can record and everybody can hear what you're saying. Ms. Pearson?
The charges are from several years ago. At the time, I was in a relationship with somebody who was very abusive. I wasn't allowed to not be with him, so I got charged with him when he committed a crime. I since then left him. I've actually been completely gone. He's nowhere near here. That was in New York. Since then, I almost completed college. I have 4 or 5 months left of that. Worked in juvenile corrections for 2 years. I've held steady employment since then. I have sole physical and legal custody of both my children. I haven't had so much as a traffic ticket since that. So.
Thank you for that explanation. Any questions for Ms. Pearson?
Why were you not allowed to leave him?
Because if I wasn't with him, he assumed that I was cheating on him no matter what I did.
No control and domination.
So you're saying he stole the items and you were there, or he made you steal items? I don't explain that.
He stole the items and I was there. We both, that when you're with somebody that's stealing, you both get charged. You both get, in New York State, you both get arrested, you both get charged because you're co-defendants. So I was with him when he stole and I got charged as well.
Ms. Pearson, what was stolen?
There were several items.
What were those?
He stole a generator, he stole a TV one time. There were several different things. I don't remember everything off the top of my head.
Are these things taken from like a personal homes or stores?
Yes.
Your jail time?
May 21st of 2013.
All right, Mr. Horn?
I'm just a little bit concerned when you said I got charged with him. You didn't have anything to do with it? You were just there for the ride?
Obviously, I knew what he was doing. No, I did not. I was afraid to tell on him. I mean, obviously, I should have, but I didn't.
And did you benefit anyway from these items that he misappropriated?
Well, he sold them and used the money, so, I mean, I'm sure in some way, probably he paid bills with money, so I'm sure I benefited in some way.
Bills with it?
Yeah.
There was not drugs or anything like that, just plain condos that he paid with the money?
I don't know what else he did with it.
Excuse me. This happened in New York, is that right?
Yes, sir.
Okay, and the fines and forfeitures was taken care of in New York?
Yes, sir.
So you don't owe anybody any fines or anything? You're clean on paper right now?
Yes, sir.
Okay. So I have just a little bit of a problem with the idea that I should have known better, this type of thing, but the idea of something made you go that way, or you said you didn't want to avoid an incident or something like that, or difficulties.
When you're being beaten every day, you kind of just do what you need to do to survive. You have nowhere to go and you have no family to take you in, you do what you have to do to survive.
How old are your children now?
My daughter is going to be 13 in December. My son just turned 10 this week.
How do they feel about this? That you're moving, get another job, a better?
They're very happy.
They're happy with it?
Yes. Yeah.
All right, any other questions for Ms. Pearson?
Just one quick one. So the broker you've chosen to affiliate with, what do you know about him?
I've talked with him a lot, and he seems...
Push that button for me.
I'm sorry. I've talked to him a lot. He seems to be very genuine.
He's a legend.
I've heard that.
He tells everybody that he's a legend. I'm surprised he hadn't told you that.
No, he hasn't told me that.
All right. He's a good man.
Okay.
All right, thanks.
All right, if no other questions from Ms. Pearson, then Mr. Massengill, what do you have for us?
If you...
Richard Hicks.
You move forward. Okay, I'll move forward again. I think if you'll check Century 21 Mass and Montgomery Records, we organization have very few problems. If you do a volume of business, you do sometimes have some problems, but you will find very few on our slate. And she'll be well supervised. I'll watch over. I think she ought to have an opportunity to try to better herself.
All right, any questions from Mr. Massengill? Mr. Horn?
Yes, sir. Do you feel you're taking a chance by adding her to your staff?
I don't have any reservations, but I will, anytime, yes, sir, I will be taking a slight chance.
Will you have some type of mentoring process that she'll have to go through, some way that you can track her work and that type of thing?
I do that.
In other words, you feel good about it?
Yes, sir.
Thank you.
All right, other questions for Mr. Massengill? Mr. Grease?
One after we vote.
Okay. Other questions from Mr. Massengill?
Mr. Massengill, do you have any concern with a person that just this recently got out of jail, letting them have access to people's houses?
I think. Dana, when did you get out of jail?
2013.
That's been 4 years ago. We use a super box, as most of you all do. There's a record of who comes and who goes in each house. If some find out that it is from her license will be sent back to you guys.
All right, any other questions? Ms. Hills?
Ms. Pearson, what have you been going to school on? What have you been working on?
Ferguson University, and I specialize in, I take forensic psychology, specializing in narcotics and criminal justice.
And where have you been working since then?
Before I moved to Tennessee, I worked in juvenile corrections for almost 2 years, and then before that, I was a desk manager and an auditor for Best Western in Weedsport, in which they never had any money come up missing, and I worked for them for almost 2 years as well.
Anybody have another question? Ms. Franks, you have anything?
I'd like to make a motion.
All right, let's hear it.
I'd like to make a motion that we accept Ms. Pearson's petition to obtain a license.
All right, we have a motion by Ms. Franks, seconded by Mr. Horn to approve Ms. Pearson. Any additional discussion? Seeing none, all in favor say aye. Aye. All opposed say no. There are none. That motion is approved unanimously. Mr. Grease.
So, a couple of things. First of all, he's stepping out on a limb, sort of, but I understand your situation, maybe not like you understand it, and so I wish you the best of luck. Second of all, I never, ever knew his first name was Van. He's never been called Van in the 30-some years I've known the man.
I noticed it in his office.
He has his name?
I noticed it on a plaque. It's a middle name.
Okay, well, good luck to you, Van. When did you get that name?
Birth.
And then you hit it immediately.
Yes, sir.
All right. Good luck to you, too.
Thank you all.
Good luck.
Good luck to both of you. Thank you.
So that counted his original name?
I don't want to hear about that again. Okay. Is Stephen McGinnis here? We took those out of order. We'll go back to them now. Okay. We wanted to take them out of order so that they wouldn't have to wait any longer. They'd already waited long enough with the other discussion that we had. So let's go back to our other medical waiver requests. The second one is Valerie Allen St. Thomas.
Valerie Allen. St. Thomas is the medical facility.
That's what he is right now. That's not where we're going.
It's only her name, but she goes on vacation.
All right.
So Ms. Allen is requesting a waiver of the $50 late fee. It appears from her note that she sent that she had medical issues come up around the time of her renewal and was unable to renew. And then there's a medical slip from St. Thomas saying that she was to be excused on around those dates for medical reasons. So,
what was the date when the license expired or needed to be renewed?
19th, 2017.
So just
Mr. Grease.
I'm just going to comment that left maybe, 720 days before the license expired to renew it? Or maybe more likely 30, 60, 90, or 120 days before the license. And so if she was incapacitated in some form or another on June 19th, that didn't do much for me.
So the license itself expired on June the 19th.
Yes.
Then there's supposed to be a 60-day renewal period, is that right?
The way I read the rule, I mean, if she renewed within those 60 days, I don't think that we have the authority to grant her the waiver.
Has she renewed?
Yes, I believe she has renewed. She renewed.
And did she have to pay late fees?
She had to pay $50 plus her $80.
So 50 was for the late fee.
Can you double check that and verify?
So she paid the $50 and now she wants the $50 back.
And I'm going to double check that to make sure she has renewed at this point.
But what the rule says is that if a licensee fails to renew a license within 60 days after expiration of the license, then you have this procedure. But that wouldn't seem to fit this situation because she did renew within 60 days of the expiration of the license. Okay. Additional questions or discussion? Or is there a motion?
I'd like to move to deny.
Second.
All right, we have a motion by Mr. Bloom, seconded by Ms. Hills to deny the request. Discussion? Mr. Horn.
I think we're back to beating the dead horse again. That if she petitioned within the dates that was given, then as far as I'm concerned, that we need to consider giving her that waiver. But now, if she violated any of those parts and asking for mercy or something like that, I can understand that. But we set the time, or somebody set the time, and we need to work with it, even if she waited 2 minutes before 12 o'clock. If she got that in on the date that it was supposed to be, what she was doing with her time is really not our business. You know, sometimes we look at people on the outside, they look good, they feel good, they're laughing and they're playing, but they could be feeling terribly inside. In other words, what I'm saying is beyond the scope of this board to go back and find out how somebody felt 20 days after they got out of the hospital. So if she did the things according to the rule, this is my thought, if she did it according to the outlines that specify, then we ought to consider granting her that license.
And this doesn't say that she was in the hospital. It shows that she visited a gastroenterologist at the St. Thomas Medical Group. That's not a hospital.
So according to Verify, she is currently expired, so she has not paid $50 at this point. So, I'm in agreement with Austin on this, that she has to wait the 60 days before we can even review it.
And if you go on, that whole clause actually says, if a licensee fails to renew a license within 60 days after expiration of the license because of personal or family health issues, and as a result wishes to request a medical waiver, then they got to do A and B. But she was under a doctor's care, according to this letter, for 2 days. So it wasn't that the medical issue prevented her from renewing within 60 days. It may have prevented her from renewing on the day that she was that it expired and on the day after, but not the other 59 days or any of the hundreds of days before, as Mr. Grease pointed out.
So
hasn't renewed, there's no fee to waive at this point.
It would be like the one that we discussed a while ago where they also had not renewed, but we agreed to waive it upon the renewal. That's what we did on the one earlier this morning. All right, so we have Mr. Bloom's motion, seconded by Ms. Hills, to deny the request. Is there any additional discussion? Ms. Hills?
But a 2-day sick versus seizure months, I don't know.
It's different.
It's just a different animal.
Mr. Horn?
Yes. I feel if we let one go with bring them back after the fees was like the second one is to we get into a slippery slope when we start trying to map out how somebody felt, why somebody didn't do this. Now, if we had them up before us and could ask them that would be a different thing, but we don't know. So I'm saying, I'm concerned that I would like to amend the motion to, upon satisfying the charges of the state, then she would be allowed to.
All right, so we have a motion by Mr. Horn that I'll take as a substitute motion, which would allow the waiver of the fees upon reinstatement, but is there a second for Mr. Horn's motion? All right, hearing none, we will go back to the original motion, which is Mr. Bloom's motion to deny the request. Any additional discussion? If not, let's vote. All those in favor of the motion, please say aye. Aye. All opposed, say no. No. That motion carries 8 yes, 1 no. All right, our next request is from, hopefully the name is right, Ed Garrett.
It is correct.
Okay, 1 for 3 is not bad. Be a pretty good Major League Baseball career. All right.
So it appears that Mr. Garrett missed his renewal time. He explains here that he had a stroke and a blood clot, so he's having some different medical issues, and there's a doctor's note. Mr. Garrett, at this time, I know Liza has spoken with him on multiple occasions, has renewed and paid all of the fees and is asking for a refund of those fees at this time.
Move to approve.
How much are the fees we're talking about? $700. Oh, wow.
We have a motion by Ms. Frank, seconded by Ms. Taylor, to approve this request. Any additional discussion?
So what's your rationale, Ms. Franks?
The man had a stroke, and he is, I'm trying to find, he was up in his later years. 70-something. 78. My father has had a stroke, and I know he barely remembers yesterday sometimes. So for those reasons, and because of my experience with a stroke patient that age, I moved to deny it, to accept it.
Marcia, do you mind restating that he's in his later years?
Well, to me, that number gets pushed further and further away the older I get.
We don't know how late it is, and maybe it's not as late as we think.
Yeah.
Okay, we've got a motion and a second to approve the request. Any additional discussion? Mr. Horn?
Yes, I would like to share this little tidbit with you if I could. I'm always pushing for let's follow the doctor rather than what we come up with. When I was a very young person in the military, they had an ironclad rule that you did not go to the doctor on your day on. On your day off, you would go. This young man, 18 years old, he claimed that he felt sick, that his side hurt or something. And they told him, you know what the rules are. You don't go to the doctor on your day off. off in 24 hours, you go to a doctor. We went to wake him up the next morning, he was dead. And it affected me all my life that somebody should have said, hey, wait a minute, well, I know what our rules are, but somebody got to step in here and make sure that this person gets a chance to see a doctor. Well, if I had any weakness in command, it was that if somebody told me they were sick, that's the easiest way to get over on me, because I would not stand in your way because I'm not medically qualified. Okay? I just thought I'd share that with you. That's why I'm really bent on trying to give people the benefit of the doubt if they claim medical problems.
And I would say, Johnny, I feel like most of us believe in rehabilitation over being punitive and giving out sentences to people. But in these cases, they all come to us, they elect to come to us and give us whatever information they want to give us. And to me, some we should accept and some we should deny according to the circumstances, and every case is different. And in this one, I found the seriousness of it. I don't see that this would be harm to the public for this man to be able to keep his license.
My hope and prayer is that on all of this, that we're as wise as serpents and harmless as doves. And that means sometimes we may have to see where somebody's sent us a request that really isn't supported. And that part of being wise as serpents, and I hope that we're able to tell the difference. And we don't always get it right, but we do the best we can.
I'll say in Austin.
So our motion that we have in front of us is to authorize this request. Is there any additional discussion on that? Hearing none, let's vote. All those in favor say aye. Aye. All opposed say no. That motion carries unanimously. All right, and we still don't have Stephen McGinnis, is that right?
But also, and I forgot to add this to the agenda, I had an email come in yesterday for another waiver. It's not a medical waiver, it's a zoning request waiver. It's an attorney out of Chicago. It's for a firm, and they are having trouble getting the zoning letter from the city of Chicago. They've been told that it could take up to 3 months for them to get this letter, and so you have the authority to waive that zoning requirement for them. The attorney has sent me some documents showing that according to some city stuff that you can find online, that it is zoned commercial, and so he's requesting a waiver of that zoning requirement, that he would get a letter from the city.
Reese?
So I'm confused. This is a new real estate company that's not yet licensed.
Correct. They've made an application for a firm license, and a requirement of that, is that they submit a zoning letter.
So they will also get licensed in Tennessee.
Correct.
Okay, but I think I would argue that if they're not licensed in the state, their home state, then it's kind of hard for us to give them a license before they're licensed.
They may be licensed in Illinois already. He didn't provide me with that information. He just said they were applying for a firm license here, and they were having some trouble getting the zoning letter.
Well, my company we've moved 3 or 4 times, and on the occasion that it takes a while in the city of Franklin to get me that letter, I have to wait. We only have what information that you have given us, and I think there's no way to know what's happening about this, and so I would make a motion that we deny the request.
Would your motion be to defer it until next month, and that it be properly presented to us with all the information?
And I would be agreeable to that, but I would say not necessarily next month, but when they can bring the zoning letter.
You want the zoning letter?
I want the zoning letter.
I don't know if I care about the zoning letter so much, but I'd like to know they're licensed in Illinois.
Well, both of those things.
They could be denied the zoning completely for here.
He may be sitting in his home or something that's not in a...
Sarah, is
So we have the
that company going to be in Nashville?
I have no idea. The attorney is from Nashville that contacted me, and it's a client of his that's in Chicago. So
I want to find out if it is in Nashville. We ought to find some expertise on the board here about because in Memphis, I mean, I can't get the letter, but I can go down and see in one day if it's zoned commercial.
Yeah, and this attorney sent me, I mean, it says that they're zoned commercial, but he's having trouble getting a letter from the city of Chicago.
Wants to get that letter.
What is the statutory reference for where they're required to provide that to us?
6213-309 says in making an application for license or change of location, the licensee shall verify in writing that the licensee's office conforms with zoning laws and ordinances. And then C says the requirements of A and B may be waived in cases of graphical circumstances.
So you could have a case of somebody asking their attorney, was this a Nashville attorney or a Tennessee attorney?
A Nashville attorney reached out to me.
Okay, so if I'm attorneyed up in lots of places, I might say, just see if you can get that wavered. You know, instead of getting the zoning letter. I don't know how long it takes, none of us do, in Illinois or Chicago.
Do you have to have a letter from the governmental authority that says you're properly zoned?
I believe that is in the rule, yeah. 1260-0203. That says it has to come from the government.
Whatever the jurisdiction is, it could be a county or...
The statute just says the licensee has to certify that.
So let me make a substitute motion.
Okay.
I move that this license be granted at the time the applicant provides proof of licensure in the state of Illinois.
I mean, so the email that he sent to me said it's about a nationwide real estate brokerage. So I assume that they're licensed, so...
This is not about whether he's licensed or not. This is about a zoning letter.
Well, I know that you can't get a license. Theoretically, I would think, unless you meet the zoning requirement.
Who knows?
That may not be a requirement in Illinois.
Well, in that case, there shouldn't be an issue. We should grant him the license.
Well, he needs to prove that you don't have to have one in Illinois.
Well, I don't know that.
I know.
Sounds like you do.
These things with all the requirements, then...
And we know that the office will be in Illinois, not for a location
Right,
in
it's in
Tennessee.
downtown Chicago, in the loop. It's in the commercial district of Chicago, so.
So we have a substitute motion made by Mr. Grease to grant the license upon proof of issuance to this person of an Illinois license. Is there a second?
Second.
Okay, seconded by Ms. Hills. Just see, maybe. Okay, now, why do you think that we should grant the license upon issuance of the Illinois license, irrespective of whether we get proof of zoning?
Let's say it is a nationwide company, okay? And so they're trying to get a out-of-state license. What do we call that license?
This is their firm license application.
I got it, but don't we call that, don't we have a name for it when the company's actually out of state?
Out of state license, if you don't stay from non-resident firm.
Non-resident firm, okay. Well, they have a brick and mortar office in Nashville. That doesn't sound like it to me. So I don't really care where they're licensed in Illinois. If they're licensed in Illinois, then I think they get a license in Tennessee.
Well, I mean, that's not a requirement of licensure for them, so, I mean, I can ask them, but...
I'm also just about equally as happy to defer for 30 days and let them present it.
I mean, I think the biggest thing is just the zoning letter. I mean, that's the only thing that's holding up their application at this point. They have all the other requirements that they need. We just need to know if we make them wait a couple months to get the zoning letter or if we waive it.
Well, I would be agreeable to approve it pending the receipt of the zoning letter. I don't have to wait till next month if they can get it tomorrow.
I was saying pending receipt of the license.
Not the license. So the zoning letter.
So you're thinking denial of the waiver period because you want them to have the zoning letter.
I want a zoning letter.
They don't need the license, though.
It's whatever we require, and we require a zoning letter.
But that doesn't mean that the firm is licensed.
Well, I think that it would behoove legal to do some research to see if he is licensed. Can he have a license in the state of Tennessee? And
He has to be affiliated with the firm, out-of-state firm, which is what they're trying to get, it sounds like to me.
It's black and white. I mean, I would just say pending receipt, because they may get it tomorrow because I have to have one, you have to have one. Why would I loosen up the regulations on somebody in Chicago we know nothing about?
Yeah, but you have to have a Tennessee location too.
I know.
You have to have a sign-out
So
sign on
that person has more leeway than I do.
Yeah,
That's not right either.
I know.
So that's my motion on the table.
The motion on the table is to grant the license upon receipt of proof that the firm has an Illinois license. That's Mr. Grease's motion, seconded by. Is there any additional discussion on that motion?
But I want to make sure that does away with us having proof of the zoning?
If this motion is passed, then we will not care whether he presents a zoning letter or not. It would just be upon receipt of proof of an Illinois license, he would get a Tennessee firm license. Is that correct,
If
Sarah?
he meets all the other requirements that's needed for a firm.
Okay. Mr. Horn?
Take a second shot at this. If Illinois, I think, is really restricting them, they are from Illinois, we will say a valid. They could be operating in another state too, but they need a license to apply for Tennessee, is that right?
Proof of occupancy, I don't know, occupancy, I think, of the, in a commercial property.
Let's go ahead and vote on this motion, and let's see where we are.
I make sure I have this right.
Okay.
So if they have an Illinois firm license, we're waiving the zoning requirement.
Saying nothing about the zoning. I'm saying if they need an Illinois license, we've got a paper trail of how to find them if we need to, because there's a regulatory agency in Illinois that's got them approved. If we get just a zoning letter, that's from the city of Chicago, it doesn't mean at all to me that they're licensed in the state. So I'm taking the zoning letter off the table in my motion and just saying proof that they're licensed in Illinois and meet the other requirements of getting an out-of-state firm license.
So do you mean to say that your motion would still require them to provide the zoning letter?
Maybe to the state of Illinois or to the city of Chicago, but not to the state of Tennessee.
Okay, so you're waiving that requirement for a Tennessee firm license,
Yeah.
as long as they provide a copy of an Illinois license
And meet the other requirements.
and meet all the other requirements of Tennessee law.
What don't you like about that?
I mean, they're willing to go through with all the requirements for a Tennessee firm license. They've already done so. They just are having trouble getting a zoning letter, and that's all they care about.
I don't think I'm in need to give a Tennessee license to a company that's not licensed anywhere else.
But I mean, we can't deny them in licensing if they don't have an Illinois license, because that's not a requirement to get a firm license in Tennessee. No.
So anybody can get a
You
firm.
can apply for a firm license.
But I'll withdraw my motion.
Okay, we're back to Ms. Frank's motion now. Ms. Frank's motion is to what?
Deny the petition for waiver
Deny the petition for waiver.
of the zoning letter.
Okay, that's pretty clear. Mr. Bloom?
The zoning letter that we need is for Tennessee and not for Chicago?
For their office location in Chicago.
How are they licensed in Chicago if they don't have that already?
I don't know if that's a requirement in Illinois or not.
Oh, it's our requirement.
It's our requirement for a firm, you have to provide zoning of your office.
But that's here.
It's for all firms.
And actually, I would say probably they're not required, or they go pull it out of their file and send it to her. So they're probably not required.
Well, I mean, I'm confused. I don't know why I would care whether they're in the zone area in Chicago or not.
The only reason you would care is because the statute says they have to be.
Was the statute, was the intent though for Tennessee firms of their, have brick and mortar in Tennessee, was that the intent? That's the way I would interpret that. I mean, it really didn't matter to me what they do in Chicago.
Probably, but.
Yeah, it just says in making an application for license, you have to have that. So, I mean,
It's a simple thing that they could get it tomorrow or 2 days from now.
yeah, and that's the issue, is they don't know if it'll take 2 days, it could take 3 months, according to this person.
They're getting it for Chicago, okay? And why do we really care about
They're
Chicago?
getting it for Tennessee from Chicago.
Statute.
Right, but it's for the zoning in Chicago, and I think the original intent of this was probably for zoning in Tennessee.
It indicates we have the right to waive that requirement.
Yes, you do.
Okay.
Okay. You've heard the motion. The motion is to deny the request to waive. If there's no additional discussion, let's vote. All those in favor say aye. Aye. All opposed say no.
No.
That motion carries on a 7-2 basis with Mr. Grease and Mr. Douglas voting no. All right, that was fun. Wasn't even on the agenda. I don't think so. I think it got hijacked. All right, next up.
Do we have any information on Mr. McGinnis? Is he withdrawing, or is he coming later, or what?
So Mr. McGinnis contacted us and wanted to come before, and we have been unable to get a hold of him for the last week or so. We've called and left voicemails.
So on to the Education Director's report. Mr. White.
Thank you, Mr. Chairman, Commission. I would submit to you the July 12th, 2017 education agenda, in which I have reviewed all the providers, instructors, and courses. Number J1 through J39. I submit those for your approval.
Thank you. Is there any discussion, or do we have any questions from Mr. White about these courses?
I have a question.
Okay. Ms. Franks.
Do any of the schools listed here have pass-fail rates that concern you?
I am sure
Going on today?
we could review those, and I don't believe any from today have concern.
If that could be a part of your review, I think that would help us as a commission to look at that. The other one I have a question about is number 127. The instructor, the company is from Mississippi, the instructor is from Mississippi, and he's wanting to teach the 60-hour pre-licensing course. We've not approved him yet, the teacher. So I'm wondering, does he have a Tennessee license?
I will have to review that, and I would ask that be continued until I check that out.
I think that would be good. And also, I'd like to know, is he bordering in Memphis and doing business in the state of Tennessee already? I would just like to know before we approve that class and that instructor that we are sure of those items, because what he's proposing is to be teaching pre-licensing to students in Tennessee. So I need to make sure that he knows about that.
The applicant sent a box of information, which I have reviewed, so the courses are fine, but I will check on the licensing and the bordering issue.
Okay, so I'd like to defer that one. I don't know until he's satisfied that he's met it, or we want it to come back.
Mr. White, is that something you could possibly look into and come back to us this afternoon?
Yes,
Sir. Okay. We'll do that. Okay. So that's J27. Any others?
Yeah, and then on J24, this is a class information, it's info on renovation mortgages. I'm not sure what that has to do with licensees as far as renovation mortgages. If you get a renovation mortgage, somebody already owns the house. I'm not sure why that's a course that we would want realtors to get CE credit for.
My impression was under the rules that as far as the FHA and the housing issues, that would be something that would be acceptable.
And how would that help a licensee?
Just the knowledge in the industry about the housing and mortgages in general.
This is a renovation mortgage. That's my problem, renovation.
It's showing a 203K loan here as well, which is a purchase.
Maybe that renovation is probably definitely need to be in there.
Well, the 203K, I have one going on right right now. I didn't write it, but it's my listing. I haven't done one for a while, so, you know.
Okay.
And real estate finance is an allowed subject matter for continuing education. Somebody might be buying something and maybe going to get some kind of loan to renovate. I guess, or real estate licensing. Don't use that word.
Structure the contract and get through the estimates and get them to the lender and things like that.
So I would move that we accept all of the classes except for number 127.
J27.
J27.
All right, is there a second?
Second.
We have a motion by Ms. Frank, seconded by Mr. Grease to approve all the courses and instructors except for J27, which Mr. White will report back to us on hopefully this afternoon, and we will consider at that time. Any additional discussion or questions?
I have a question.
Yes.
I don't know, it's the last class.
And it doesn't have a number. That was going to be my next thing I was going to ask.
I'm going to guess it's J40 or something.
That's a course for discussion.
Okay.
Coming up next.
Oh, we're not voting on that yet?
No, sir.
Okay, then, okay.
Yeah, so the class called Marijuana in Real Estate is not part of this motion.
Okay, we're keep going then.
All right. You've heard
I guess I'm just a little hazy over here.
Sometimes.
I'm getting hungry, I don't know what that means. What's left of that table?
All right, let's vote. All those in favor of the motion vote aye. Aye. All opposed vote no. That motion carries unanimously. Mr. McMullen abstained on J25. Okay, so are there any additional instructors that we need to approve, or were those covered? I think they were covered by that motion.
There were 2 instructors. I'd submit those for approval as well.
I think a motion covered it, as you stated.
Yeah, I think that those were covered except for J27.
That's correct.
Which we will talk about this afternoon.
Absolutely.
Okay. You had a matter, the PSI handbook update?
We didn't get to discuss that one yet.
Right. Okay. You want to do that? You want to talk about marijuana in real estate class? Do that now?
Yes, sir, Mr. Chairman.
Okay, Mr. White?
This class was continued, this course was continued from last month to determine and to do an outreach to the provider and to the instructor to see if they had any additional things they would like to bring to the commission's attention. So I looked into that, and they did send this, which I want to read into the record. Here's some of the information for the board to consider regarding approval of this class. There are many southern states with pending legislation regarding medical marijuana usage, including Tennessee. The purpose in large part of this course is to provide the background to the legislation that is now rampant in the news with states legalizing or shooting down legislation, and how this is impacting real estate in that federal law and state law do not agree in cases of legalization. This places real estate agents in an interesting position between federal and state law. So in order to understand where we are and where we're going, the course provides a history of the interests involved in the whole legalization debate. Case studies show where interests are colliding in real estate, including real estate professionals and the class they serve are caught in the middle. So this was a statement they presented, and I just present that again for your information and consideration of this request to be approved.
Mr. Reese.
I was going to yield back to you, Mr. McMullen. Does this course fit into an approved category?
Well,
finance. No, it's not finance.
Yeah. That could be, I guess. Well, let's see. Categories that could potentially encompass it maybe include the real estate business, legal aspects of real estate. I don't know, Tennessee real estate laws. I mean, it would just be well, that's not really real estate law. No. Additional subject which the commission may require.
The problem is, there is no law, there is no statute, there is nothing to teach at this point. I don't want us to muddy the water. I think this is coming soon, but I don't think we're there yet until we know what the laws are going to be. How do we teach a class about it? And so I'd be opposed to that class.
Ms. Taylor, do you want to add something?
I was making a motion that we deny this request.
Okay, we have a motion to deny the marijuana and real estate class. Is there a second?
Second?
Seconded by Ms. Franks. Additional discussion on this topic? Mr. Wood?
Is there proposed legislation right now in our state about it? That was something that was read there, but I've not heard it.
Last month, when I looked at that, I read about it, and it was, and this is by my memory, but I think it died.
It was about medical marijuana.
I don't know if, it certainly wasn't approved. It may still be pending next year, because that's all one General Assembly, but
I'm certainly interested in it, but I think we did not.
I think we need to know what the laws are before we can teach the course, and we don't have the law in Tennessee.
I just wondering, Mr. Douglas, well, there seems to be, this is a trend, that's sweeping the country right now, and realtors are involved in RPAC, and, part of what we are here for is to protect the public, and I think it would be incumbent upon us to allow a course to be taught that would educate realtors on potential legislation and whether they want to involve themselves in, advocating for or fighting against that particular legislation, just knowing what kind of impact it would have on the real estate industry in Tennessee. So I'm just asking, what do you guys think about that? It seems like to me it might be something that would be beneficial.
So we don't know what the legislation will be when it
Well,
comes
it's a day late and dollar short if you wait for the legislation to already be passed before you start teaching courses on it, I guess is what I'm stating here.
I just think it muddies the water to teach a class on what potentially could be a law. If there's a law, then we know how to teach that class, and this is what you do and this is what you don't do. Otherwise, to me, it'd be a waste of my time sitting in a class like that and everything was potential. What's your takeaway from something potential?
I think it could be prudent for a real estate professional to want to learn about this, but our question is, do we think it's worth giving CE credit? And that's where I kind of have drawn the line. I'm not so sure it's CE credit worthy yet.
I think it eventually will be, but I just don't think we're there yet.
okay. Any additional discussion? Mr. Horn?
Yes, sir. A few years ago, we faced the same thing with meth. And everybody said, well, that's up in the mountains, and it's not down here. But eventually it's going to get down here. And then when that happened, the realtor that went in and sold the property, was a proper cleanup done? They didn't know what they were doing. And a lot of people ended up getting sick because the person who, I fault the realtor at that time for not making sure that they had followed state cleanup procedures. What all this thing is going to do, I don't know, but I believe that somebody ought to have some type of preparation to know that what marijuana dangers does to property. And I don't think we need to wait until the cows get out before we used to close the barn door. We need to start looking at this now, and I think you're in the right arena by go ahead and start to look at this before it happens to Tennessee. I hope it doesn't, but it just might.
Would this proposed class address any issues of if there is criminal activity that occurs on a property with respect to selling or growing marijuana, any subsequent issues that could come out of selling that property that a realtor should be aware of?
Yes, Mr. Chairman, including forfeiture laws and other proceedings that are in state law. Of course, federal law, I believe, prohibits cannabis, but there's some inroads into the other states. 21 of the other states have approved this, other states' commissions, and I think 3 have denied it.
All right, any additional discussion on the motion, which is the Ms. Taylor's motion to deny the course? All right, let's vote. All those in favor of the motion, please say aye. Aye. All opposed say no. 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 I believe that motion passes on 5 to 4.
Their names on the,
Let's have, okay, we've had a request for a roll call. Let's call the roll.
I'm just kidding.
This is the motion to deny, so if you're voting yes, you're voting to deny the course.
Don Grease. Gary Blaine.
Yes.
Rick Douglas.
No.
Marcia Franks.
Yes.
Diane Hills.
Yes.
Johnny Horn. Austin McMullen.
No.
Montane Taylor.
Yes.
And Bobby Wood.
Yes.
5-4.
As I thought, the motion passes on a 5 to 4 vote, and the course is denied. Thank you for calling the roll. Let's try to move on. Anything else, Mr. White?
There are two other things that were to consider today, and one, there's some copies beside your desk relating to an issue that the commissioners had asked me to look into regarding a little research on CE courses approved in Tennessee that are also approved in other states. For instance, with a non-residence license in Mississippi, are there quite a few courses that could also they would get credit for in Tennessee and Mississippi because they're approved in both states. So what I endeavored to do, I sent a request out to 3 of the largest national providers of education, McKissick, CE Shop, and Brightwood Kaplan, and I have those responses, but we couldn't put it on the iPad, so unfortunately, so what you see is the spreadsheets that were sent to me by virtue of that, so you look over some of those courses and get a bird's eye view of what is going on and how somebody in Mississippi, Arkansas, West Virginia, and North Carolina, all those states contiguous to Tennessee, what courses would also be available to them and approved in those states.
Thank you for sending that. Any questions about that document? I'm sure that if you have any offline, Mr. White would be happy to address those. Anything else?
We're happy to address anything the commission brings my way, Mr.
Okay.
Does this correspond with that also,
There are 3 separate, actually, they were not defined, but one is McKissick and one is the CE Shop and the other is Kaplan.
Gotcha.
I'm sorry they were not available on the iPads, but at any rate, the next thing was there was sent down to me to ask for an inquiry about real estate property management licensing. And I endeavored to do an Orello listserv, and those are on your iPads, which reflect what states that responded. I had 23 states that responded. Good response. And if you look through that, you'll see that all those...
What number is on the iPad?
I think it's listed as inquiry sent to all real estate.
14. Okay, got it. 14, yes.
So the beginning pages there, you go through and you'll see all those states that have some sort of separate licensing for property management. And versus the last page, you'll see those states with no separate licensing for property management. What I thought was most interesting and stunning to me was that most all of these states have an issue with property management complaints. And I found that to be something to bring to your attention, because I think that's really interesting that other states are having the same issues that we are. And I guess it would be interesting to discover what are the underlying causes of that, and maybe that would help us to craft some type of response or remedy to that. But regardless, I wanted to bring it to your attention, and so you have some idea of what the other states are doing with property management.
Well, to that, I would say, from attending Orello meetings, the 2 topics that are always top of the list are teens and property management. And the property management part seems to be mostly unlicensed activity. So, I think the people who have licenses and who are doing property management, they're the ones who seem okay. The real problem is unlicensed activity.
Based on your research, how many states had a separate license for property management?
But let's see, how many? Let's see there.
obviously for us, that would be a statutory movement, but
Here we've got 7 or 8, but I didn't get every state, but I did get a pretty good response from at least half the states. In the District of Columbia and Saskatchewan, Canada.
Nebraska requires a separate, they require additional CE for property managers, property management people.
I thought it was interesting too about their statutory language and their rules, that just to bring it to your attention to see if that could fit within our statutory framework, and you might want to think about that for to those in the industry what they can and can't do.
And you know, so the question becomes, how do you handle unlicensed activity? Some states are doing PSAs, they're putting it on their websites, information about what's required to be a property manager. There are some things that we can do that cost us very little money to do, and so it would be my suggestion that we look into some of those type things, since property management is so prolific here.
Ohio that has the videos on their website, so we can look at those.
Yep.
All right, anything else, Mr. White? Anybody have any questions for Mr. White?
Mr. Chairman, members of the commission, I don't have anything else. I do know that some discussion will be had about the PSI manual, the bulletin, but
Okay, thank you. Thank you very much. Thank you. Come back and see us this afternoon about J27, I think was the number.
we'll do after lunch.
Okay, thank you.
On the PSI booklet, is that something we're going to talk about?
Okay. Go ahead and do that now. I think that is next on our agenda, so who's heading up that discussion?
I can look that up. Ralph and I worked on it together. When we went back and looked at the PSI manual, I made quite a few changes. So on the iPad, and what was sent to you is an updated version. Sorry, it's not in track changes, but you would have struggled to read it in track changes because I made a lot. So Sherry's made all of the changes, and so we just wanted you all to look at it and make sure that you agree with everything. Most of the stuff we changed, and let me open it really quick. We're on the first few pages dealing with the licenses and what the requirements were. The only thing that we didn't touch and we highlighted, because I know it's something that we talked about when we first started looking at the PSI manual, is on page 8 of the manual. And that's where it says description of examinations, and that goes through the procedure for when you don't pass the first time, second time, and third time. And I think that the commission can discuss looking at that and how it was laid out, because PSI has it in there, and it was told from a commission at some point that's how they wanted it stated, but we wanted to make sure that you all agreed, because we direct PSI on what goes in here.
What you're referring to, is it on what was emailed out to us last week?
Yes.
It's on that one?
Yeah.
Okay.
Yeah, it's under description of examinations.
Okay.
And it's page 8 of the PSI manual that was sent to you last week.
I think one change, or one thing that's there says if you don't pass the exam a certain number of times, you have to get 12 hours of CE credit.
Yes, it says for an affiliate broker and broker examination candidates who fail the first attempt at the examination may retake it as soon as they want. However, they cannot schedule until the day after the examination. Those who make a third attempt at the examination must wait 30 days after the second. Those who fail the third attempt must obtain an additional 12 hours of approved education and wait 30 days before making a fourth attempt. After the fourth attempt, any subsequent exams may be scheduled immediately with no waiting period.
This is kind of my thinking, because the way that's presented at the schools and stuff in PSI is that that's a real estate commission rule, and that's not a real estate commission rule, the 12 hours part.
Correct, but it had to be directed by the Real Estate Commission. When I talked to PSI, they don't make any changes to this without it coming from the commission. So whatever's in this manual is essentially referring back to our rule that says we followed the vendor's instructions. So
this is just, as I've thought, I'm not convinced the 12 hours of more CE credit is helpful, because at this point, they're still not a licensee. And so they really have no practical knowledge to apply the continuing education to.
Where would we have enforcement?
My thought is get rid of the 12-hour part, but just make it after you've not passed it that certain number of times, then make it where you got to wait 30 days from then on, every time, 30 more days. I think that would give them
study or something.
Yeah, that would, to me, that's giving them more proper incentive, because the way this is, after a certain number of time, then they can just keep coming back every week and doing it.
So this would be dropping the 12 hours of education requirement, and then where it says any subsequent after the 4th, it would say you have to wait 30 days between each exam.
Yeah, they can just keep taking it every 30 days.
The 12 hours isn't anywhere in here, is it?
No.
I'm thinking it might be one of those, what's the other thing, not a rule, but a policy that we're trying to get rid of.
I've reviewed all of our policies. There are no outstanding policies at this time that are not on our website, so.
Okay.
This was a question when we visited our association.
Yeah, I had someone
On the
come up to me
front row.
and question me about what was in the PSI manual.
Yeah, and it was this, because one of their instructors' niece or granddaughter had
It
that.
was, yeah.
And the PSI said there's nothing in this that TREC is not approved.
Correct.
So if we want to take it out, let's take it out.
Well, what about where it says, after the 4th attempt, any subsequent exams may be scheduled immediately with no waiting period? Are we going to change that to 30 days? That seemed to be what Bobby was saying.
You want to
See, here's the problem, though. I have to go to a class, and I got to take that test immediately, or it goes out my brain, okay? So to tell somebody you got to wait 30 days, is that helping or hindering?
Like somebody who can't keep anything in their brain, is that
Maybe that's my problem.
Obviously, getting pitching the first time, so.
Let's study again.
See, I understand your intent, but I would argue that people on the Hill would consider what you're proposing a barrier to entry to this profession, because you're putting them off 30 days at minimum, as opposed to the way it's written right now, which gives them much quicker chance to retake the test.
I mean, like someone like me. I mean, we're different learners.
I would say between the 3rd and 4th attempt, you have to wait 30 days.
I would say.
After the 4th, if you failed it 4 times, you don't have to wait anymore.
You just keep going.
Yeah.
You go day after day after day.
Because there's some companies like CSI, they guarantee you will pass your test because you get to keep coming back to them for refresher courses until you pass the test. I don't know if other companies do that, but
Barber's cheaper the
that's the
second
biggest
time
thing.
around.
I would just say, keep on, if you just do it, you have to wait a day between, keep taking it, because anybody that's taking it 4 times and doesn't pass it, they're just guessing anyway, they're not really studying, they're just
it's gonna be,
hitting a different blank, you know.
Well, there's going to be some time lapse on getting registered
Right.
with PSI.
But the way it says on the first one, you have to wait
So-
a day till you apply.
Okay, so the way it's written right now, it says, if you failed it twice, you have to wait 30 days before you can take it the 3rd time. If you fail it the 3rd time, you've got to wait 30 days and do 12 hours of education before you can take it the 4th time. If you fail it the 4th time, or any subsequent times, there's no waiting period and no education. So, Mr. Wood, is your motion to just eliminate the 12-hour requirement and leave everything else the same? Or is your motion to eliminate the 12-hour requirement and impose a 30-day requirement even beyond the 4th failure?
My proposal would be get rid of the 12 hours, and then after the 4th time, you can only do it every 30 days.
Okay.
And with the intent being, I'm not trying to exclude anybody, I'm trying to give her some incentive, and I'd encourage people to come to me and say, hey, I'm not, there's review classes, give them proper time to get review classes, and let's turn an agent. I mean,
That's the motion. Is there a second?
Second.
All right, we have a motion by Mr. Wood, seconded by Ms. Taylor. Any additional discussion? Let's vote. All those in favor of the motion say aye. Aye. All opposed say no.
No.
That motion carries 8-1.
Sarah, you got all that?
Yeah, so what we'll do is we'll make those changes. I don't know if you all want some more time to review this to make sure you agree with all the other changes that we make. Might just take a quick read through it, just.
Hopefully everyone already read it.
Well, are there any other changes that anybody wants to make?
I have a couple of
Or does anybody want more time to look at it?
Ms. Franks.
On page 2, under qualifying questions, number 4, it says, note include all traffic violations that are alcohol or drug-related, reckless driving and/or DUI are misdemeanors and must be disclosed. We're not requiring those things to be, or are we?
As far as I know, when they send in their application, they're supposed to include all of that on the application.
And why do they need to include that on the application if we don't even hear those items or consider them?
I assume if there's any probation served with those or jail time, they just kind of make sure that it doesn't affect.
Okay.
Traffic violation. A speeding ticket.
Don't sit or keep burning. And then the other thing I wanted to ask about on page 4 was the examination fees. They're $43, and I'm wondering, is $43 our cost that we have to pay PSI? Where's that $43 going?
That does come from PSI, I'm pretty sure.
Yeah, we always tell people.
That's their price.
Because they told us that we regulate that price. Mm-hmm.
We can do some research on that.
Well, it's pretty odd.
Because I heard it was recently 55 and it actually went down to 43.
Okay, I would just like for us to do, I mean, I'm okay to approve this unless people need more time, but I would like for us to maybe have future conversations about that exam fee.
And can I piggyback on that? Because that kind of excited me. And this is my thinking. There is a cost to the Real Estate Commission incurred for just keeping up with this. And the only person that's benefiting from that, in this example, is PSI, because they're getting the entire $43. Is there a situation or where, as a Real Estate Commission, we can say the fee is, and I don't care, pick a number, 65, okay? And the difference between 65 and 43, that money comes into the Real Estate Commission to kind of offset some of the expenses of just trying to keep up with all this information.
Or have an administration fee, whatever PSI sets, have an administration fee that goes to track of X, whatever X might be.
Because $43 for an examination, to me, seems like a very low number.
It does.
I'm not wanting it to be extravagant, but I'd just like to have more info on that. And there's other companies, too, that do exams other than PSI. And we, as a commission, we usually get direction from our executive director when those renewal periods come. And I think are they 2-year contracts?
I think that when it was reported the last time, it might have been like 2019 or 2020 that our contract with PSI was through.
Okay.
I believe we asked that a few months ago when we discussed that.
Okay, if we could be sure about that, because, and then when that renewal time comes up, then we need to look at what's being charged, instead of just, that'll be a question other than just, okay, let's take them.
I was thinking it used to be more. I was thinking when I took mine 20
I saw on the website, and I was told that was old information.
I was going to say, 55. That's something people are retaking. They're trying to
Probably easier on a computer at this point, too, than what they were having to do.
Yeah, they're probably doing it a lot, yeah.
Because you just look at people like home inspectors. I think a home inspector pays about $245 to take the test. I mean, so I'm not saying we go there, but.
And I also wonder for like that, if it's because there's a lot less home inspectors, so they up that price a little bit.
And I'm going to the Orwello September annual meeting, and I'll be sure and ask, there's 2 vendors, I'll be sure and ask them about that.
Can I ask one other thing, or a couple of things? It talks about PSI. It says on page 6, and it gave a list of their examination centers, but they have centers outside of our state, and can people take it there too?
I would have to ask PSI if they do allow, or if they have the capability to have the Tennessee exam outside of the state, or if you have. Okay. So we could ask them to put a note that there are.
No, they got it down there.
Okay.
The paragraph is kind of a catch-all. We got other centers too. Call us.
And we could bold that if you think it would be better, just to make that stand out a little
I didn't
more.
realize it until recently. I'd heard that. And then on page 7, under it says examination review. To paraphrase, it basically says that PSI, changes their test to go along with the laws. How does that information get to them? Because I'm not convinced. I think when the last people did the PSI testing, they realized that the rules had, the loss has not been made.
So I will tell you, since that has occurred, I've had probably multiple emails. I can't think of that lady's name right now, the PSI lady. She's emailed me multiple times saying, hey, I noticed that there was an update in the law. Can you send me what the new law is? I'm having trouble finding it. So I've shown her how to sign up for Notifies too. So she'll get notifications anytime we have a rule change. So.
But otherwise, they basically every 2 years come and do, like we did in that meeting, audit and see what's changed. It took all day, and there were so many things that was incorrect about their exams.
But I don't think they've been for a long time.
I don't know.
Well, I mean, it was about like this manual. We looked at things on there that we were like, that's not right. So, I mean.
All right, any additional comments or questions about the PSI handbook?
11:30.
Does anybody want another month to look at it, or are these changes all that we have? They want more time.
No, did we need a motion, or are we just good with this?
Just if you got something,
No.
speak now for Ultra P.
We'll make those changes and send it to PSI.
All right, it's 11:30. Do we want to go ahead and do the executive director's report, try to get it knocked out before we go to lunch? Does anybody have a problem with that?
I think you should. All her report is not very.
I was going to say my report is, if you will take a look at the report that's on your iPads, I believe that we do have some speaking engagements coming up in August. I think that they were going to look at maybe taking some of those off because there are a lot for me to have to go to, and a lot that are Friday, Monday, Tuesdays. So I think they're going to look into that and see if somehow we can consolidate. And since it's a requirement of the executive director, and I'm not technically the executive director, I don't...
Who's looking into that?
Mark was going to talk to Carter, I believe, to see if there were some of those that we could put on hold for now until we got an executive director.
Especially the August ones, because they've already been advertised, is the problem.
That's our other concern, is that we've advertised those. The one in Chattanooga is the date of our meeting, so other than that, I can report that staff is doing really well. Our numbers continue to go up, and
A replacement for Brooks' position?
so I submitted on some interviews 2 weeks ago, and so I believe they're looking at hiring someone to bring in.
So they'll hire someone before we hire the new executive director?
The person that they're hiring isn't in Brooks' place, it's, who's that person that? I think that they were going to leave another space open for the new executive director to hire after they come in, but.
Make sure your speaker is on.
I just want to know on the June statistical report, acquisition representative registration, 2,330. What is that?
They're timeshare people. They're the initial contact out on the street, trying to get you to come into the center to be handled by somebody else.
Okay, well, that's all right.
There's lots of them.
Then the next page, if can we go to the next page, or we already, on the exams taken by license type, it is amazing to me that the Tennessee affiliate, Broker National, only, that 44.90% failed, and it's amazing to me that Tennessee Broker National 57.14% failed. That's just an amazing thing. And do we know if that's after being tested one time, twice, the 4 times, or the 6 times? What do we
That has taken it the first time and multiple times all mixed in there.
And you've got a list of that Ross provided us, the Tennessee Real Estate School summaries. There's some astounding numbers of failures, and that's why somehow we need to be flagging, especially ones that are 100%, 51%, 70. I would say anything over 51% needs to be monitored, Ross, so that we can, that's why I asked you earlier, we know that all these schools are in good standing, because if they're over and over and over, got more people failing the exam than passing, then we need to know that. And we need to look at that.
Well, I think less than 51%. I think if you're getting in the high 40s percentage of people failing an exam, that's really making a statement.
And that goes to protecting the public, because those people who are taking the exams, they are the public. And,
If I'm not mistaken, I actually think we have the audit authority over those courses, so that Ross could actually go in and send it on a course to make sure.
Yes. That's a good question about those percentages on that, and I don't know who came up with those numbers, but like on the Tennessee Broker National that Ms. Taylor was just talking about, it said 47 tested, 27 passed. If I do 27 divided by 47, that's 57% passed. But the thing says 42% passed. But it's only on that line then some of the other ones, the numbers don't exactly add up. Like Tennessee Broker State, 58 took it, 46 passed. 46 divided by 58 is 79.3%, but it says 78.0%. Does anybody have any idea how
I
these
just checked
numbers?
it on the bottom, and the timeshare pass should be 69%, not 72.
Yeah, or the acquisition agent is a pretty easy one, because 5 took it, 4 passed, that's 80%, but it says 93 passed.
Sherry, do you know how those numbers? I'm trying to figure out how they're pulled.
Okay.
That'd be cool.
Explain all on core.
Mr. Horn.
I have a question.
Yes, sir.
When you have 47 people take it and 20 pass, the music or the musician? I mean, the test, is it really what it's supposed to be? Is it encompassing everything that person needs to know? Or is the knowledge outdated, maybe stale? Well, in other words, there's some reason for it if there are normal people that only half pass or less than half pass, or maybe more than half pass. I get concerned then. I remember when I teach, there's a lot of questions we throw out because nobody got it. So that's me.
Well, that's why making sure our teachers are qualified is very, very important. But Johnny, also, my daughter was licensed 2 years ago, and every day she was so frustrated because people slept through the classes, or they had their music going on in their ears, or some of them, she said, were obviously high in there and would go drink at lunch and stuff. And so, the teacher doesn't have any authority to say, you got to listen up. It's kind of like in college. You get it or you don't get it. You pass or you fail. And that's what's happening. And I think a lot of people think that getting a real estate license is easy, and honestly, it is easy. And so they don't think they need to hear too much, So it's partly some of the people who are looking for an easy job where they don't have to clock in places. And so I think part of it is the students, but I also think the teachers. My daughter had, the first week, she had 5 different teachers. And on the last day, she said, "Oh, Mama, we had a real teacher today." If you've gone to school and been to college and things like that, who real teachers are. So it's both things, and that's why I always try to double down on the schools and the teachers to make sure that we try to make the best situations in these schools that we can, because it's a problem with all these failures.
I know we had was cooperate, graduate, other words, the people sit there with things that they use, this type of thing. It ought to have some grading system into the all grade, and one of the things, we show a video, and that used to be sleep time. Well, I stopped that by watching the video with them and then asking them questions about the video. And the score that they made would come off their top score. Well, they took all their things out of the ears and started watching. So that's what I'm talking about. We create equality within the teaching structure with the requirements of those students. And I'm thinking if we're not, maybe we need to make a strong statement that, you know, the school is going to be held responsible for their teaching methods, and the students are going to definitely be held responsible for the material that they obtain. I'm just running my mouth.
The last thing on my Arello report is the future. And one of the things I have on here is how we teach is critical. Interactive teaching is what we need. Transition to skill-based learning models instead of learning facts to pass an exam. Teach communication, marketing, and leadership classes to increase licensee success. Promote courses that benefit and protect the public. That's what the classes need to be more than, here's what the teachers do. Now, remember this, highlight this will be on your exam. And so people go through, their ears pick up, and they will highlight. And then they go back to the music or whatever they were doing. So, you know, I don't know how we monitor that, but I'm open to Ross for any suggestions on anything that we could do to improve our schools.
So I think keeping track of the pass-fails for each school is really important.
We're publishing that now.
And that is, I mean, that's the same thing as having an ADT sticker out in your front yard versus, you may not even have a system, but that ADT sticker might keep somebody from coming to your house, just like this pass-fail would do. I don't want my name on there, you know?
But I think we have to always remember too, that licensing does not teach you to be a real estate agent. It teaches you to pass the test. Your education starts once you sign on with the broker. And, you know, that's where the education started for, I think, every one of us.
It's kind of like college, though, too. It's the same.
So can I have one question about your report, and then I'll take a break. So what's troublesome to me is it looks like open complaints increased like 50% over the last several months. Is there a reason why, or is it just the time of the year, or coincidence? But it's a 50% increase. Have you looked at them? Is there any common thread or anything that's...
I mean, I have no explanation for why they're increasing. It seems, I mean, we're getting a lot of complaints that are going straight to our consent agenda because there's no violation or rhyme or reason to them. People are just looking for somewhere to complain. But I mean, I can see if we can figure out why. It could just be the time of year.
Yeah. I got an answer. Of the 27 complaints that are not on the consent agenda, 10 of them have to do with unlicensed activity. That's 38%. So 4 of 10 of our complaints now have to do with unlicensed activity.
It could be that's where the problem lies. It could be because we've started our outreach. It is why. We tell people, you know, if you see this, you should file a complaint. Otherwise, we can't. Because, I mean, I get that call every day. What are you going to do about it? And I always tell them, there's nothing I can do about it until you file a complaint.
So it's astonishing when we were in West Virginia that people would say, oh, you know, we only had 21 last year. Or we have, and Sarah and I are sitting there thinking, oh my gosh, we got 90 a month.
I think it goes back to we don't have enough proper incentive to keep people from doing unlicensed activity. That's where we are.
That's why we have to keep that strong.
And licensed activity come up to you at our association. Did you have it at Knoxville?
I don't think so.
We don't let that happen.
They don't do that.
All right, well, thank you for that report. It's now 11:45 and we are going... Yeah.
Sharon, you made a statement. So I asked you how things are going and you made a statement. Could you share that?
Which one?
You said that things were...
That things have moved smoothly.
You had just had some figures that are processing.
Our processing time has actually gone down
I just thought you may want to know
the
that.
last month.
Listen, we're doing it without, these other states have lots of people out there that are investigating. I mean, there's a huge group of investigators that meet every time we meet.
So good job. I just thought y'all may want to know that. It was just nice to hear. Good job. Yeah.
Thank you for that, Mr. Bloom.
I hate to cut into your time, but next month when we hear again from Mark and Carter, it really disturbed me what the conversation we had earlier. We had one of the best legal minds that we could have on the commission, and he drafted what we thought was a conclusion to the matter that the staff said was happening, and then they said that the staff said it hadn't happened. Well, at the break, I talked to some of the staff, and they said it wasn't possible for us to get those figures from IT. And so they extrapolated, here's how many people need 120 hours, and here's the hours that they currently have. I'm going to guess they're not going to get them. So that threw it into that category. We don't know what we voted on, because we voted on what they said was happening. We actually drafted a proposal that the staff said would help them. And I think my responsibility and everybody else's responsibility in this board is to look after the public and to look after our industry and to look after our staff. And we were doing that. And we have the right to do that. They said we have the right to do that. And now we are being directed by one legislator who said, somebody in my district didn't like what you did. And that offends me when I reviewed what actually happened. So they're coming back next month with that, so just put that in the back burner and think about that.
All right. With that, we will take a lunch break, and we'll reconvene at 1 o'clock. Thank you. Yeah.
Deputy Commissioner wanted to
Brian?
Brian,
Okay. I'll come back at 1. See how that works.
I think it's the governor's initiative. All right, Ms. Smith.
Yes.
Number 16.
16, 2017-005061. Complainant attempted to correspond with the property management company who is advertising their name and contact information on various rental signs and through their website. The respondent is an assistant to the property manager at the property management company. Complainant states that he called the company's phone number several times but was never able to speak with the property manager. Respondent called complainant back to ask him questions and stated that she would get back to complainant after speaking with the property manager. Complainant saw several rental advertisements on social media posted by the respondent and provided a copy of a single post on respondent's personal Facebook page. Complainant was unable to verify that respondent or respondent's employer are licensed. That was part of the complaint. Counsel has confirmed that respondent's employer is a licensed real estate firm and respondent is unlicensed. Complainant had also heard about issues in relation to the respondent's company and decided not to pursue a transaction with them. Respondent states she does not specifically recall speaking with complainant. Respondent further states that she does not answer questions that would require a license, as she is aware of what an unlicensed assistant can and cannot do. Respondent does admit to being confused about social media rules and now realizes that as an unlicensed assistant, she cannot post properties on a personal page or post available properties to social media. Respondent admits to realizing this error and deleted the social media post immediately. Subsequently, respondent states she and the firm will diligently follow the guidelines for licensed and unlicensed employees, in addition to apologizing for any inconvenience caused. Counsel recommends a civil penalty for unlicensed activity based on the respondent's admission of her error and misunderstanding of the law, as well as proof of the unlicensed activity based on the copy of the Facebook post. So the recommendation is a consent order for civil penalty in the amount of $1,000 for unlicensed activity.
Move to accept counsel's recommendation.
Ms. Franks moves and Mr. Douglas seconds. A motion that would confirm council's recommendation. Is there discussion? Mr. Woods.
I would say is that...
Microphone, please, Fontaine.
The other thing that I would say is this was opened in 125, and we were still working on these rules of advertising. What was right or not right on the web pages. So I think there's a little gray area for that, and we let people go during that time.
But would it apply to an unlicensed?
No, it wouldn't.
Oh, okay, so.
It wouldn't. So,
My question is more about the $1,000, so the facility we have it. I've noticed that in some of the other states, for unlicensed activity, they do it, it's $1,000 per occurrence, but they put a maximum on it. But the way they interpret it, if you're unlicensed today, that's $1,000. You're unlicensed tomorrow, that's another $1,000. Unlicensed the next day, another $1,000. Where did we come up with the interpretation it's $1,000 per transaction, let's say?
Ours is the same thing, it's per day, $1,000 per day.
If you want, if you can justify the count.
And prove it.
Yeah.
Okay. I'm thinking. Keep that in
All right, anything else? The motion is on the floor and is to accept council's recommendation. Those in favor of that motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 17.
2017-005101. Respondent is the principal broker for the firm in the complaint above. Respondent confirms that the unlicensed assistant only performs administrative and secretarial duties at the firm. Respondent spoke with the assistant about the complaint, and she explained she did post about one property on one occasion, but immediately removed the post after being notified of the complaint. Respondent further states that the firm has weekly sales meetings and training classes to teach the agents, assistants, and staff the proper ethical way to conduct their business in accordance with TREC regulations. Respondent is not on Facebook much, nor is the assistant a Facebook friend. Therefore, respondent only became aware of the erroneous post upon being notified of the complaint, but assures that it will not happen.
I believe that we accept council's recommendation.
Second.
Motion by Mr. Douglas, seconded by Ms. Franks, that council's recommendation be adopted and the principal broker be offered a civil penalty of $1,000 for failure to supervise. Let's discuss. If not, let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. 18.
2017-007571. Respondent, if you don't mind, I'm just going to summarize the first two paragraphs because there was a clerical error that caused a deposit into the complainant's account of $840. Respondent provided proof that the clerical error was reversed. So taking that to the third paragraph. Counsel called respondent and left a voicemail on July 6, 2017, requesting that respondent return the call to explain why respondent no longer has an active firm license. Respondent has not returned counsel's phone call. Counsel checked respondent's website, which shows respondent offers services including property management, renting rooms, selling rooms, commercial real estate, and HOA management. When counsel attempted to click on the links that explain the services and details and check the homes listed for rent or for sale, every link prompted a message that stated the website was under construction. Therefore, counsel recommends a civil penalty for unlicensed activity based upon the information I could gather from the website as it looked on its face.
Move to accept council's recommendations.
Okay. Motion by Ms. Frank, seconded by Mr. Horn. Offer the respondent $1,000 civil penalty. Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. 19. Now, this is kind of a funky one. I think you're going to have to read this into the record. As much as I'd like for it not to be. But
I am ready. Have both 19 and 20.
let's see. Let's get 19 and see where we are.
2017-009191. Complainant was hired by a licensed agent at respondent's firm to be an outbound sales associate in August 2016. Complainant states that the licensed agent, which I'm going to refer to as the licensee, did not tell complainant or complainant's coworker who was hired at the same time that complainant and the coworker would need a license to legally solicit real estate services. Several weeks after complainant was hired, complainant claims the licensee enrolled complainant and another coworker into real estate classes without complainant's knowledge. Upon realizing he was enrolled in such classes, complainant told the licensee the complainant could not attend the classes because they conflicted with the complainant's college schedule, and complainant unenrolled himself from the real estate classes. Complainant further states that licensee told complainant if complainant did not obtain his real estate license, complainant would be fired, so complainant agreed to sign up for the classes again in January 2017. When complainant explained to the licensee that the licensee failed to inform complainant of the license requirement prior to hiring complainant, complainant states the licensee said that he thought he had explained the requirements, but if he did not, he sincerely apologized. Complainant realized that it was illegal to solicit real estate without a license while he was going to school to obtain his license. Complainant also states that the licensee implied that it was unethical for complainant to be doing the tasks he was doing over time, but never told complainant it was a criminal offense. Complainant feels that the licensee has no problem behaving unethically and misrepresenting the law to trick employees into working for him legally. Respondent states he did not participate in the interview or hiring process of complainant and further confirms that neither complainant nor the coworker were licensed at the time respondent stepped down as principal broker of the firm on January 13, 2017. Respondent states that complainant was an hourly employee of a specifically named group within the firm that has its own offices, and the licensee who hired complainant is over this group. His name is in the group name. Respondent states he overheard the licensee, whose name is in the title of the group, speaking with complainant in early September 2016, and it prompted respondent to ask the licensee if he planned on having complainant call potential clients. The licensee told respondent he wanted complainant and the coworker to become inside sales agents as soon as they were trained. Respondent reminded the licensee that anyone who makes calls by phone or in person to potential clients for the purpose of securing real estate business must be licensed. Respondent states that he remembers seeing complainant carrying signs out the door, which made respondent think complainant was doing acceptable personal assistant tasks. Respondent inquired to the licensee over time about complainant and was told complainant was enrolled in real estate school but had a conflict with college classes, and complainant would start in January 2017. Respondent explains that this is not the first time this issue has been brought up and addressed. In early 2015, respondent was notified that the licensee had contracted with a company that used personnel from the Asia-Pacific region to call expired listings in an attempt to schedule a listing appointment. As principal broker, respondent confronted the licensee, and the licensee argued with respondent, stating that calling expired listings were, quote, warm calls, not cold calls. Respondent then contacted the managing broker of the firm, and an email exchange ensued between the brokers and the licensee. This email chain provides documentation showing that the managing broker and principal broker provided the licensee with instructions about licensing requirements, along with a personal assistance do's and don'ts from a TREC FAQ policy statement number 93-CPS-001. Respondent and the managing broker also explained that any calls to expired listings were considered cold calls because the calls represented the first contact between an agent and the person trying to sell a property. The licensee was informed that complainant would need to be licensed to make such calls. In summary, respondent states that he immediately addressed issues with the licensee who hired complainant when respondent learned of the licensee's plan to groom ISAs. Respondent further states that the licensee was well aware of the requirements for licensing even before making outside calls to potential clients in early 2015. After receiving respondent's response, complainant emailed the department and stated the co-worker that was still working for the licensee would be leaving soon. The co-worker told complainant that the licensee was advised that the department would be investigating him and asked the co-worker to come up with a cover-up story and lie about everything that had transpired. The co-worker told complainant he would not lie for the licensee. Complainant did not provide any documentation to prove the licensee planned on covering up his actions. Based on the admissions of the respondent regarding the affiliate broker's actions, regarding his assistance and what he allows them to do, and respondent's attempts to address the issues with the affiliate broker, counsel recommends a reduced civil penalty for failure to supervise the affiliate broker and recommends a civil penalty in the amount of $500 for failure to supervise.
So I can be straight with this. The complaint is against the principal broker of a company.
Yes.
And below him is a managing broker, and below him or her is a group leader. And below that group leader is this complainant.
So the one I just went over was the principal broker. Number 20 is the affiliate broker who hired.
I got it. I'm just trying to understand the structure.
I think it's just a group leader. I think it's a principal broker and a group leader.
Well, then here it says, respondent then contacted the managing broker of the firm.
Right, the managing broker doesn't have a complaint against him.
Okay, so it's principal broker, managing broker, apparently a group leader that hired the licensee.
Which is the respondent in number 20.
Okay. I just want to make sure I understand the
Yes,
structure of how this
yes.
is set up. And so-
The way this reads, the principal broker is not the one that is licensed. So is this the license of the principal broker that we're talking about?
Yes.
The managing broker has no responsibilities, only the principal broker does.
And so I don't care how many, to me, I don't care how many tiers are involved here, whether it's principal broker, manager broker, group leader, doesn't matter, the principal broker is responsible.
Yes.
And so, personally, I would argue a reduced civil penalty in this case, because it sounds like this has happened before. They've had the same discussion before, and it's happened again. I mean, I think a recourse for a principal broker who's serious about his or her business would send the license back to the state. Broker release it at some point if they're going to keep doing it. So those are my comments. Now the floor is open for anybody else.
Okay, so you're thinking that it should not be reduced, it's the penalty.
I don't feel any reason to give this principal broker a break because he's tried to delegate authority that he can't delegate.
So instead of $500, maybe it should be $1,000.
Well, actually, I was thinking there's two people that were doing this, and it's two of them doing it though. And so I was thinking 1,000 for each one of those that were doing unlicensed activity.
In this, on this one, we're just talking about the one broker.
We'll get to affiliates in a second.
Yeah.
Okay.
I'm sorry.
So this broker is the one that was frustrated that he had a licensee under him who had the problem before, and he had tried to tell his licensee that has a group, don't do this, you're not supposed to be doing this, and he thought he was watching him, thought well, he has somebody only making cold calls, not making cold calls, and only carrying signs out, and thought he had it under control. But you're right, that he had done it in 2005, 15 and stuff, yeah. Do we still have that track, frequently asked questions policy statement? Not anywhere? I think I took it down. Anywhere? He took it down.
We took it down last year.
Okay. And so this complaint was filed.
Okay, the floor is open for a motion. Mr.
Civil penalty in the amount of $1,000. I recommend civil penalty in the amount of $1,000.
Okay, I'll second it, but I'd like to have a little discussion.
Okay, I got Mr. Horn first.
Okay.
Did you have a comment, Mr. Horn?
Yeah, I'm having a little bit of a problem. This is the second time we've been through this with multiple entities that seem to be to blame or share the blame. The good book tells us that the sins of the children should not be visited on the sins of the fathers and the fathers of the children. And it seemed like we were going from broker to a principal broker who all had something to do with that. It's actually one person that had something to do who did it. And these other people, I mean, I know you can get them for failure to supervise and all that, but the idea, again, if one person is responsible, I think that person should be held responsible.
To that person.
But the broker is responsible for everything.
The motion at the moment on the floor is a civil penalty of $1,000 to the principal broker. Is there further discussion? Let's vote. Those in favor of that motion, vote aye. Aye. I'm sorry, I had to make your point, ma'am.
So, is this the broker now, or is this the broker who is gone? Because this broker is no longer there.
This was the principal broker during the time the
situation took place in this complaint, but left after the hiring of complainant. So he was the principal broker during the relevant time. Does that answer your question?
Okay, so we were just about to vote.
Sorry.
That's okay. Those in favor of the motion to offer a civil penalty of $1,000, vote aye. Aye. Those opposed, no. That motion passes unanimously. Now, Erica, just so I keep this straight again, we have a principal broker we've just discussed, we have a managing broker, then we have a licensee who apparently hired 2 unlicensed people to work.
Yes.
This is about that licensee.
Yes, this is the licensee that I've mentioned many times now. 2017-009031. Respondent is the licensee who hired complainant mentioned in the complaint above. Respondent states complainant was made aware that he would need to obtain his real estate license during the hiring process and confirms complainant was enrolled in real estate school as of January 2017. Respondent states complainant's duties included calling around to homes sold by the firm to make the neighborhood aware of the sale and to inquire whether others would be interested in selling their homes as well. Complainant would set up appointments for respondent to meet with anyone who was interested as a result of the phone calls. Respondent further states the complainant did not meet with any clients, nor did he provide any real estate services or advice other than information gathered from public records. Respondent also states complainant was never paid based on the sale of a house, but was paid hourly plus a bonus for each appointment he set. Respondent released complainant from his duties at the firm on February 8, 2017 because complainant would not provide a social security number for tax purposes. Respondent feels that the complaint was filed in retaliation because complainant lost his job. Respondent states he was not aware of licensing requirements that would apply to complainant and the tasks he performed at the time, but apologizes for any mistakes he has made in his understanding of the licensing requirements. Respondent then admits that he misunderstood the rules for what an assistant can and cannot do, and has since put safeguards in place to ensure this does not happen again. Going forward, anyone that will be hired will meet with respondent's broker first, and the broker will explain the different tasks that require a license and those that do not, and a contract will be signed and notarized by all parties, detailing all responsibilities. Respondent also provide a signed notarized statement from the coworker mentioned in the complaint, which states the complainant told the coworker his plans to file a complaint once complainant realized respondent wanted a social security number. According to the coworker's notarized statement provided to counsel, the coworker told complainant that he wanted nothing to do with the complaint and states he likes working for respondent and wanted to continue working for him as long as possible. The coworker further states respondent did notify complainant and him during the hiring process that they would be required to obtain a license and that respondent would pay for the classes. The coworker also states that respondent told complainant and him that they could not offer real estate services until they were properly licensed, and confirms the duties and tasks he and complainant performed, only including calling homeowners about recent sales in their neighborhoods and setting up appointments for them to meet with respondent upon request. Complainant sent a rebuttal to respondent's response where he states that respondent is lying. Complainant further states he left the firm because he didn't trust respondent with his social security number. He was not fired. Complainant provided screenshots of 2 texts from respondent to complainant showing that respondent is not being truthful about respondent's claim that he never paid complainant based on the sale of a house. The texts show respondent was going to pay complainant for, quote, 2 listing agreements on top of the appointments. Complainant provided a copy of the job description, which states complainant would be paid $75 for each signed listing agreement, plus 5% of GCI from listings obtained through appointments set by complainant. The job description also states duties were, quote, calling homeowners 35 to 40 hours a week, using either circle prospecting methods or expired scripts to set up listing consultations and nurtures for team members. Real estate licensure required within 2 months of starting, end quote. Based upon respondent's admissions of his mistakes and understanding the law and allowing complainant to perform tasks that would require a license, counsel recommends a civil penalty against respondent for employing complainant without a license and allowing him to perform such tasks while he was unlicensed, even after the principal broker instructed respondent on the issue. Therefore, my recommendation is a civil penalty for $1,000 for violation of TCA 62-13-302, which prohibits employment by a broker of an unlicensed broker.
Well, I have two questions. Is this the same person in the previous complaint that had been around since 2015?
Yes, that had been counseled by the principal broker in 2015.
Never gotten a license in 2 years?
Oh, no, he has a license. He's hiring people and allowing them to do things that...
All right, so he does have a license?
Yes.
Okay.
And he's had these two people since.
The person that's paid 5% of the gross commission, is he licensed or unlicensed?
No, he's unlicensed.
Violation. That's about...
Right. I think what we need to do is count up the violations. That's $1,000.
And it's been since August of 2016 for these two unlicensed people.
Only one of them filed the complaint. The other one is not on the side of the complainant, so he would not be affirming anything.
Did you see those text messages?
Yes.
And it said what it put out. So that person, so did you get the feeling that when the licensee was actually compensating these unlicensed people then?
I did get the impression that he was, it was right around the time he was about to leave and be fired or quit. And the respondent texted him to say, I owe you this for 2 listing agreements on top of the appointments. And the listing agreements to me is wrongful compensation. It's based on the payment of that, or the purchase of the house.
You got a licensee that's hired 2 unlicensed people.
Yes.
Okay. And then they're also paying those 2 unlicensed people from the licensee and not the broker.
Yes. But only the one. The other coworker is not cooperating with us. Wouldn't cooperate with us. He's saying it's not true.
We have 2 listings that we know.
Well,
We have 1 unlicensed person that we know. That's 3.
Safely assume he's got 2 unlicensed people and he's doing the same with both of them.
I do. I just... Is that provable? I don't...
Hard to say, right?
Hard to say.
It depends on if he's going to lie on the stand if we were to call him.
There's a lot of stuff there.
Just do with what is unlicensed person. I mean,
I only have the text to the one person, so I don't have anything showing, but I do have the job description, but I don't think anything in the job description says that he's paying them for something that an unlicensed person, can do.
well, they're calling homeowners 35 to 40 hours a week.
So, if an unlicensed person is not allowed to call the homeowner, then absolutely, then I would change my recommendation.
Using his scripts. Yeah.
And circle prospecting methods.
About it? Let me just ask one more question. So Erica, you're referring to 62-13-302.
Yes.
Now, and it refers to it's unlawful for a licensed broker to employ or compensate. Is your interpretation even if it's an affiliate broker that hired somebody, is your interpretation still apply?
My interpretation is the question whether an affiliate broker can hire. I'm sorry, can you just repeat the thought?
I got it. That's my interpretation. Okay. That if you have somebody in your firm who is an affiliate broker who you have designated as they're hiring people, then they can be held to the standard of 302.
What about the principal broker?
Absolutely.
At the same time. I mean, we just did the principal broker, didn't we? But there may be something they want to reconsider that or something. I'm just trying to follow through. Okay, Bobby, so you want to take a shot? Let's talk about the affiliate broker.
Okay, affiliate broker, I think we have of 2 violations of hiring unlicensed activity, and that's $1,000 apiece. And then there's also 2 violations of compensating somebody. And if a licensee is compensation not coming from the broker at $1,000 apiece.
12/16/02/41. That's team. Receive compensation.
So the motion is $4,000 total.
You had 2 listings also. They got 2 listings, they got paid $75 for each of those 2 listings.
They made the appointment.
Oh, I would, hopefully you'll add some classes in here for this guy, too.
So what I'm unsure about in your motion is, I don't know whether this affiliate broker actually paid the unlicensed people who, or did the principal broker pay them on a commission disbursement?
The principal broker states that he was not involved in the hiring process at all and was told, basically lied to by the affiliate broker, and did everything he could and thought that they weren't doing anything that would require a license.
These 2 hires were paid by the affiliate broker directly?
Yes.
Okay.
And they also were calling 35 to 40 hours a week. Is that an additional? Or are we just going to put it all up at all in compensating?
I was just kind of looking at it, maybe I'm being too lax then. I was just thinking each $1,000 unlicensed activity on each person, and then get each one of them, or for each person that they were compensating them directly rather than the broker, which really and truly I probably shouldn't have been able to do anyway because they weren't licensed.
So is that 4,000?
4,000. But I'm willing to listen if y'all want to do something.
I second that.
Okay, we have a proper motion on the floor right now, which basically addresses 2 violations times 2, each violation times 2.
I think he needs to take a class. Now, which class would be apropos for him, I have no idea.
Contracts, it's not.
Ethics, but there's not really 8 hours of ethics.
Either doesn't know or isn't paying attention to the law. So I don't know if there's a course that just talks to
law. About just law.
Well, I'd like for it to be specific to, like, statutes that are applicable to the Tennessee Real Estate Commission as a thought. I don't know if there's a course to that effect.
Well, there's all kinds of law courses.
About the core course, but not to be included in CE.
We've already required that.
Yeah, but I think that's Gary's right on it, because the core course is everything, and a lot of it is real estate commission rules.
Not included in the CE.
Maybe he might need to take it twice then, is that what you're saying? Yeah. Or it could be somebody with grandfather too.
Yeah.
What is this person's license?
Amend mine and add that has to take the 6-hour core course, but that's in addition to his regular CE.
Okay. Anybody else want to discuss? I'll repeat the motion before we vote. Okay, the motion offered by Commissioner Wood and seconded by Ms. Franks, I think. Is that you, Martha, or Marcia? It would be a $4,000 civil penalty broken down into 2 parts, $2,000 for 2 counts of hiring unlicensed brokers, and $1,000 times 2 for 2 cases of paying licensed brokers for performing real estate license activities. In addition, there'd be a requirement that the licensee complete the core class in addition to his regular CE requirements within 6 months of acceptance of the civil penalty. That's what's in front of us. Any questions? All right, let's vote. If you're, yes.
I mean, so,
After talking through it,
the August, September, October, November, December, January, February, I'd like to multiply by 7
I
months.
feel like now that we've talked through it and understanding more what, that they can't even call, possible clients, he's been really defiant to his principal broker in addition to the commission. I mean, when the principal broker came to him and said, you can't do these things, he argued with him. So just taking a class, taking a class.
Suspend his license for a time.
Or hers.
Fish, there was, here's my part, he, licensee wanted the social security number of these unlicensed people, and that to me is,
Well, he probably had his own LLC.
I don't understand. To me, when you hire somebody, that's one of the first things you do is after their name, because you know you have to come up with somewhere. I don't understand that.
doing this whole business over here.
The company would have that if the company hired him, but there's something going on because
The company didn't need it because they weren't paying him.
So we can't audit him, he's a licensee.
Egregious compared to other things that we see.
It really is.
And obviously, even the principal broker had no control. What's going to happen next is they'll move to another company that knows nothing about it. So that principal broker won't be alerted to
What
it.
if we suspended his license for a while?
That's what I said.
Maybe.
I'd like to amend my recommendation.
Just let it go.
We've already amended your recommendation like crazy.
Okay, I'd like to make an amendment to it.
What would you like to do, Ms. Franks?
I would like to suspend their license for, how many months? For 180 days.
That's 6
We'll
months.
see, we're going to find out. Is there a second to that amendment? Okay, it's on the table, properly moved and seconded. That is an additional amendment to the previously stated motion. It's an amendment to it.
In addition to $4,000
And the core class.
in the core class.
That this licensee's license be suspended for a period of 180 days. If this passes, and this consent agreement is presented to the licensee, that licensee will have every right to say, I'm not going to do it, and come for a formal hearing, which...
And if I were that attorney, I would say, Ms. Franks, where'd you get the 180 days from? Is that arbitrary and capricious?
It won't apply if we go to a formal hearing. All this is off the table at that point. All right, so let's not get too far ahead of us right now. You've heard the motion, you've heard the amendment offered by Ms. Franks and seconded by Ms. Taylor. Is there further discussion? If not, we need to vote on this. All right, it's on the table. Let's vote. Those in favor of the motion as amended, vote aye. Aye. Those opposed, vote no. The motion passes unanimously. Thank you for your input on that one. 21.
2017-009032, and this was just opened in error. It's a duplicate of the complaint above. We wanted to keep it together. So
Move to dismiss.
Franks moves to dismiss. Ms. Taylor seconds. Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. 22.
22 is very long.
Let's talk about that for a second. Your recommendation says that discussion of suspension is appropriate. So if we're going to get to that point, then we probably ought to go through this unless you can summarize it succinctly.
I think I'd like for you to hear all of it, unfortunately. So 2017-010-631. Respondent is the listing agent of a home the complainant is trying to purchase. Complainant also has an agent representing her in this process. Complainant states that respondent refuses to submit her offers to the seller and told complainant she was not going to get the house. Complainant further states that respondent hangs up on complainant's agent when she tries to call him. Complainant requested documentation showing the offer was rejected and respondent refused to provide it. Complainant states she has made 2 offers to purchase the home and respondent flat out stated he would not submit the first offer. When complainant confronted respondent, he immediately listed the house as pending, only to return it to an active listing a few days later. Complainant states she has text messages showing respondent told her friend the house was available during the time he refused to submit the offers. Complainant claims respondent does not want to share profits from the sale of the home with another realtor. Complainant states she contacted respondent's principal broker by email about the situation but did not receive a response. Respondent states that he received an offer from complainant's agent on January 31st, 2017, and he presented the offers to the sellers on February 1st, 2017. While respondent was communicating the offer to the sellers, he received a text message from the complainant's agent stating she was withdrawing the offer on behalf of the complainant. Respondent further states he sent a text to the complainant's agent that saying very inquiring whether complainant was still interested in purchasing the property after he tried calling the agent many times without an answer. Respondent sent a second text to the agent asking if the complainant provided a reason she withdrew the offer, and there was no response from the agent. On February 8th, 2017, complainant's agent texted respondent and asked if the property was still available, and subsequently received another text that complainant was submitting an offer. Respondent received the offer, which was $30,000 less than her previous offer that was withdrawn.
Interrupt for a second.
Yes.
So at the bottom of this big paragraph you're reading, you basically say everything I've read so far is okay.
Yes.
So she follows that.
Yes, I just thought that because it is very fishy, you might want to hear the things that he allegedly did that I can't necessarily prove right now. But it kind of falls in line with him possibly behaving unethically. Let's see. Okay, so they received the second offer, which was $30,000 less. Respondent told complainant's agent that he had 3 offers on the home and asked if she wanted to approve her offer. As a result, complainant's agent sent a text asking if the seller had responded to the complainant's offer, and respondent told the agents that the sellers did not want to look at the offer. Respondent provided copies of the text messages to complainant's agents to support these statements, which I saw. Complainant's agent then asked respondent to provide a written rejection of the complainant's offer, and respondent states he sent the rejection to the agent by email. Respondent provided a copy of the rejection of complainant's offer, the second offer, and complainant admits to receiving the rejection after requesting it numerous times, but does not believe the sellers knew of the offer and feels the respondent rejected the offer on his own. Further, respondent explained to the agent by email that the sellers were offended the complainant withdrew the first offer of $209,900 before they could respond, and were further offended when the second offer was so much lower. Respondent states he did have the contract pending because the seller had accepted another contingent offer at the time. The pending contract was eventually voided due to repair issues, so respondent made the listing active again. Respondent denies all allegations made by the complainant. Counsel does not find any evidence that respondent violated any statutes or laws with regards to the summary above, but I think it will make sense why I wanted to read those things as I continue. Complainant then sent a rebuttal to respondent's response to the complaint and made further allegations that led counsel to investigate public tax records. Complainant stated that respondent was the actual owner of the property he was purporting to be selling for the sellers, and provided screenshots of public records showing that respondent owned a certain LLC, a tax assessment record showing that respondent was the owner of the property. Counsel went to the city tax assessor website and verified that the sellers who signed I'd like to amend this, the sellers who signed the contract, the sellers who signed the rejection of the second offer. So that's where their signature was on that second rejection. Signed a quitclaim deed and handed the property over to respondent via an LLC. I needed to add that too. On October 8th, 2016, the property was sold and transferred from respondent's LLC to a seller via warranty deed on April 17th, 2017. Evidence shows the respondent was the rightful owner of the property at the time complainant made her offers, but did not disclose such to complainant, and used the seller's names on both documents where complainant made an offer. And I'd like to just amend that to say I only have a copy of the second rejection with the seller's signature, so not both. I'm sorry about that. The sellers also signed the rejection of the second offer, but counsel does not have a copy of the rejection of the first offer, although their names are on the document as the sellers showing the first offer. Respondent's name is on all documents as the seller's agent. Based on evidence obtained through internal research on public record websites, counsel recommends multiple civil penalties and suggests the consideration of a suspension of respondent's license for a time frame to be determined by the commission if necessary. Counsel finds the respondent's violations to be extremely egregious, misleading, and unethical, and questions if the respondent is a danger to the public. Counsel's recommendation is discussion of suspension if appropriate, or in the alternative consent order assessing a civil penalty in the amount of basically $4,000 violations.
What are those rules that you, what are they?
The first $1,000 violation.
I see it, yeah, okay. I just wasn't paying attention.
And we have not presented the rebuttal to the respondent, so I don't have his account of any of this. I just have the complainants and then the actual deed that I printed showing that he did own it when all these things were being done. That's why I thought you should hear all of the steps he took without ever saying he owned it.
And so did you confront him with that information?
No. The licensing division or the complaint division does not send rebuttals for a response.
He will. If the commission decides to move forward, he will. He'll.
Commissioners, you see and have heard council's recommendation. Is there a motion?
I'd like to know, you said discussion of suspension. Can you tell us a little bit more about why you think maybe there should be a suspension? Have you discussed this with Mark also?
Yes.
Okay.
I just feel that having your client quitclaim deed a property to you and not disclosing that, I feel like there's a reason he did that, but I don't know the reason because I haven't been able to talk to him about it. And it just seems, to me, I don't understand why you would do that unless you're benefiting in some way. And if you are benefiting, that's just abusing your professional license. And I also have a copy of just a screenshot of something showing that another property was quitclaim deed to his LLC, but I have nothing else on that. So that was another.
Mr. Wood?
I guess I first want to say, I'm kind of like, wow, Eric, I mean, that's good that you picked up on this. Not everybody would have picked up on
right,
it.
Well, I was ready to dismiss it,
yeah.
And then I read that and I said, no way did this guy do it, and I went and looked.
That was slick that you picked up on that.
You investigated it.
Yeah, I mean, that was good. I'm like,
you don't do that very often, Mr. Wood, so congratulations.
On the record, I'll say that's the first time I've ever heard Commissioner Wood.
Yeah, he believes it. If he said it just now, he means it. That's good. But his mind at the same time.
I would have been quite proud of myself if I would have caught that one. That was a good. I like that.
I I was proud, but I was like, this seems too crazy to be true, so that's why I said it needed to be discussed, because I thought maybe I'm missing something, or there's a rule I don't know about where you can do that as an agent, and I just couldn't find anything.
Based
upon that, I'd be silly to not kind of go with your recommendation. I like the idea of the civil penalty for the different $4,000 total for the 4 different violations that you've pointed out here, but also in addition to that, I guess we call it suspend or revoke the license for the 180 days.
So that's short-term, revoke is take it.
What are we doing the last one?
We suspended it for 180 days.
Suspend the license for 180 days in addition to that.
Motion offered by Mr. Wood, but it's now looking for a second.
Second.
Now that second has been found, would adopt council's recommendation and additionally suspend the licensee's license for a period of 180 days. Discussion.
Well, why didn't he need to take a course too? I mean, he could take 6 courses, it looks like. Ethics would be one.
Of that core class, that's what we gave the last person.
Okay, let's do that. Let's do that. Same thing.
Beyond.
CE within 180 days beyond the required. And Eric, I do need to say you didn't capitalize Realtor.
You didn't put Realtor in there, but you...
Are you a realtor?
That's what Bobby said.
License it.
I'm surprised you didn't point that out to you. Let's not lose track of where we are.
I need a shock, something I can wear to shock me when I type that.
We'll discuss it after the meeting. Well, thank you. Okay, you've heard the motion. This is discussion. $4,000 civil penalty, court class within 6 hours in addition to required CE, and 180-day suspension of his license. Let's vote. Those in favor? Mr. Bowman, I'm sorry.
Well, this is where I'm going to maybe be shot out of the water, but I'd like to add that he attend one of our regularly scheduled monthly meetings of the Real Estate Commission in the next year.
Right. So I think for purposes of getting this clearly, I think we'll divide the question. And I'd like to vote first on Mr. Bloom's amendment, if there's a second to it. Second. Okay, so that's on the table. The motion, if it approved, would be to require this licensee within the next calendar year to attend a full meeting of the Tennessee Real Estate Commission. All right, the chair will speak against that motion only because of discussions I've had upstairs. I don't think that's a good idea. Mr. Green?
I would strongly recommend we not do that.
Hold on, the commission has its own will, it can do what it wants to. And so with that said, let's vote on Mr. Bloom's motion that will require attendance at a full meeting of the Tennessee Real Estate Commission. If you're in favor of that motion.
Let me ask a question. Is this person, would it be wrong to say, is this person that we're talking about in Middle Tennessee where it'd be easy to get to?
I would not.
I really don't know where he is. I don't know that I should.
I do.
I don't think it's part.
It shouldn't be.
It should be part.
It shouldn't care.
It should be part.
It shouldn't care.
The property was in his name during all this. Did the property subsequent to that transfer to someone else?
Well, it's in the LLC's name that he owns, and then April, I went and looked further, even way after this complaint, to see if it was transferred from him to sell or to a buyer, and it was transferred from his LLC through a warranty deed in April of this year because he sold it.
I'm wondering if the original seller ever knew that they had signed a quitclaim deed.
That's what I'm wondering.
Yeah, may not have known what they were signing. They thought they were signing a listing agreement or something, and signed a quitclaim deed.
I didn't even think about
And that's why he didn't.
That's why I wanted to read all that.
For offers, yeah.
Okay, so we're gonna take up Mr. Bloom's motion. Offers.
Can I ask a question about Mr. Bloom's motion? Because everybody says don't do it. I mean, that seems to be the will of some, I don't know how many, and you say don't do it. Why? Because you're going to vote upstairs is going to vote against us after we pass this motion?
Let me tell you, first of all, I've never talked to Mark about this, so you're going to get his opinion, not something he's told me.
Well, I know, but upstairs is going to reverse it.
It's the department's opinion that it's a disparate treatment for people who live outside of Middle Tennessee, have a higher burden of coming to the meetings as opposed to people who live where the meetings are being held. And so I believe that is true, and so that's why, and I know that my superiors believe it, so.
And wasn't there something passed the 1st of July that they can, any decision we make, they can overrule that decision?
Well, the Senate Bill 1217, yeah, was that the North Carolina don't.
And I'll also say this, Gary, I'm gonna vote against my motion, my second, because I think this is too big of a deal. I don't want to get clouded with this issue. So I'm like, let's vote and see what happens there.
Put your second back.
I'm not vote for it. It's okay.
Yeah, and I just think this is a big situation here. I don't want to get clouded up with the meeting part. Yeah, I don't want to get clouded.
Okay, let's vote on, because it's been moved and properly seconded, we'll vote on Mr. Bloom's amendment to the motion. In favor of his amendment, please vote aye. Aye. If you're opposed to that amendment, vote no. No. Okay, that. Skip, what do you do, Diane? I'm sorry.
No, I voted against it even.
Okay, you vote with him if you want.
Because I appreciate it, I may have to stay home tonight.
All right,
it is hard for me to.
That motion will be under control.
I would be curious to know if he received a commission for the sale of owned the property, sold the property, and profited from the sale as well.
If we have a hearing.
Let me ask the results of the vote first. And that amendment offered by Mr. Bloom, seconded by Mr. Woods, failed on a 1 aye, 6 no, 1 pass vote. Now we're back to the main body of the motion, which is $4,000 suspension class we've talked about. And frankly, I sometimes hope, Rick, that they'll say, I'm not going to agree to that. I want a formal hearing where we can find those kind of things out. That's
Worse for them.
Okay, let's vote. If you're in favor of the motion, please vote aye. Aye. If you're opposed, vote no. That motion passes unanimously. All right. Thank you, Ms. Smith. Number 23.
2017-010661, the respondent is the principal broker for the affiliate broker mentioned in the complaint above. Respondent was contacted by the complainant and then by complainant's agent at respondent's request 5 days before the complaint was filed regarding complainant's concerns. Respondent discussed the issues with complainant's agent over the phone and subsequently found no evidence to support the complainant's claim that the affiliate broker refused to submit complainant's offers to the seller. Respondent also discussed the complaint with the affiliate broker, and the affiliate broker provided a timeline of events regarding this issue. Respondent believes there was a breakdown in communication at some point, but the evidence supports the affiliate broker's timeline. Respondent does not understand why this complaint was filed based on his review of the matter and all documentation available, unless the complainant's agent did not communicate the affiliate broker's responses from the seller to the complainant. Counsel finds that there is evidence of a failure to supervise based on the lack of knowledge of the principal broker regarding the violations, and recommends a civil penalty of $1,000 for failure to supervise. And I must say that principal broker has no knowledge of the complainant's rebuttal, so this summary only addresses that first part of the complaint.
Move to accept counsel's recommendation.
Motion made by Ms. Frank, seconded by Ms. Hills, that council's recommendation be adopted and a civil penalty of $1,000 be offered to the respondent. Discussion.
Well, it seems to me the broker should know more about this guy than, I mean, it seems like, I'm sure the agent told him what he wanted. what he wanted him to hear, not the real facts, but
All right, let's vote. Those in favor of the motion, vote aye. Aye. Those opposed, no. Motion passes unanimously. 24, let's, if we can, skip down to the new information.
Complainant contacted counsel and requested that this complaint be taken out of litigation monitoring status based on the extended length of time this complaint has been in such status. Complainant has been engaged in a civil lawsuit for almost 2.5 years, and the parties have been unable to reach a settlement despite numerous attempts. Complainant has exhausted much of her financial resources and cannot afford to take this civil case to trial due to the financial burden at this time. As a result, the complainant feels that it is unfair that respondent can avoid the requirement to respond to the complaint while it is in monitoring status, and thus avoid being held accountable for any violations that she may have committed. Complainant states respondent has unlimited financial resources and can continue to draw out the civil process to avoid dealing with either case, while complainant cannot afford to pursue the civil case further. Complainant feels that it is necessary for the Commission to hear the evidence and information provided by the complainant and the respondent without further delay, because respondent could be causing harm to other members of the public. Complainant has been unable to provide new evidence of any new violations by respondent since the complaint was put into monitoring status, but takes issue with continuing to wait until the civil case is resolved to make a decision regarding the complainant's complaint, as there is no hearing set and no evidence of a settlement being reached. So my recommendation is to take the complaint out of litigation monitoring status if possible, and I state if possible because there is a legal binding order that the respondent, or agreement that the respondent and the department signed putting it in this status.
When we sign, first of all, I don't care for litigation monitoring agreements because it kicks the can down the road, sometimes 3 years like we're facing here. And when we sign those, we enter into those agreements with parties who agree that we won't take any action, but that whatever happens at the court, or any settlement or judgment or whatever, will be shared with the Commission and given to the state for us to present in their case in order for the Commission to make a determination. What we have here is a situation where we don't have any new information. We have talked with this, both Erica and I have talked to this complainant, and she's obviously very upset and frustrated that the civil case has not come to fruition. We have asked her what new information is, and basically the information is that it continues to drag out. Now, if we move it out of litigation monitoring, which would be fine with me, we may get challenged because we have a valid litigation monitoring agreement and no new information has come. So this party could take the matter to Chancery Court and ask for an injunction, not taking it out of litigation monitoring agreement because we don't have any new information. So with that, I don't know, we can attempt to take it out. I don't know what the respondent will do, but we'll find out.
How is this a detriment to this lady or this gentleman? Continue to keep it in litigation monitoring.
She believes it's a detriment. However, I don't know. I can't speak to what her reasoning is. She is just frantically, desperately wanting this out of litigation monitoring.
Is it a detriment to her civil case, maybe? Since it's taking so long and money?
Or maybe she thinks it's just dishonest.
I think she believes this. This person, I think, believes that the respondent is dishonest and is getting away with A, being able to drag out through the courts the civil procedure, B, not having to come and face their day in front of the Real Estate Commission.
Doesn't hinder her from doing her real estate business.
No.
The complainant is the one that's saying
It's the one that's reached out. I've talked to this complainant multiple times.
And she's made it very clear she just feels like her complaint should be heard after 2.5 years of her trying very hard. And I have proof of the settlement offers going back and forth, and just her explaining how much money all of this is. I believe her when she says, she has limited financial ability to take it forward, whereas the respondent, I believe, has unlimited and is really avoiding both.
So your recommendation, though, the recommendation is that we take the complaint out of litigation monitoring status if possible.
Well, I think what that recommendation really means is for discussion, whether you think there's new information, to remove it out of.
But we couldn't, so when we put it, it was because we thought it was going to litigation.
And
so we really never
And it has gone to litigation, it's just.
And it did. So we never really talked about it.
I always thought litigation monitoring would help us get more information.
Right.
That's the idea.
But it has not.
Well,
How long is too long to wait?
how long is too long?
So at this point, we can't ask questions about it, about the case?
Well, the respondent's not required to respond at all while it's in this status. So that's another reason the complainant feels like, well, the respondent doesn't even have to present his answer. So that's why she really doesn't want money, obviously, or anything out of this. She just wants it to be heard, both sides to be heard.
Yeah, I mean, I've explained to her multiple times that even if you find against the respondent that she doesn't get any money, she understands that. She just wants this, she thinks that this person did so wrong that it needs to be just heard.
Yeah.
That's that judgment.
If it comes out, if we take it out of litigation monitoring, at that point, the respondent will be forced to reply. He has, or she has not had to at this point.
Right.
So at that point, then we've got to take a look at both sides and decide whether we think there's anything to the case.
Maybe that'd be the best thing to do if it's been 2.5 years.
Is there a time limit on anything about this? Like if they haven't heard a case in 2 years or so, that we get to look at it, or what?
No, there's no time limit. That's one reason I don't care for litigation monitoring agreements. I think there should be there's no time limit on this one.
Should another one come up just for my information? Is it up to us to put a time limit on it?
I would encourage an attorney recommending a litigation monitoring agreement to put a time limit on that without, at least demanding an update as to when the resolution should come.
And Erica, one little thing. I think John asked you to skip down to the new information without you reading that case into the record, the number.
Oh, yeah, I did not read it. Would you like me to read that at this point? 2015-022-4251.
Okay, so here's what I think. I don't think the respondent asked us to put this in litigation monitoring. I think we did that on our Now we've got a complaint asking that we take it out. We put it in on our own volition. I think we can take it out.
I think that's the only thing that we can do because we really need to hear from the respondent.
Right. So it's my sense that 2.5 years is a long enough wait to get additional third-party information, which it doesn't look like we're going to get. So I would think that the right thing to do is get this case back on our docket after we have a response from the respondent. Not necessarily up to me, but a motion that said, let's take this out of litigation monitoring and get it back in the process would be an appropriate motion. Okay, Ms. Frank's motion, Ms. Hill's second, that we remove this case from litigation monitoring. Is that enough of a motion for what we need to do?
Yes.
Okay. Further discussion.
I was going to ask, I thought sometimes that we put it in litigation monitoring because maybe we didn't want to affect the outcome of the court case. that they can go, well, look, the real estate commission got them. And by us doing this, are we going to possibly affect the court case? What do you think?
So here's kind of what I think. That's a fair question to ask. So let's say the respondent replies, and we have a discussion like we're having today with a recommendation from counsel. What's the outcome going to be? Either we dismiss it, or we assess a civil penalty. And if we do that, if this guy is, as he's described, he's probably going to say, I'm not going to agree to that civil penalty, I want a formal hearing. So we're probably, just a guess, we may be months and months away from ever having to do anything with it. The process started, makes sense. You've heard the motion, is to get this thing back on the docket at some point. Mr. Taylor?
Can I have, as part of the motion, do you mind putting it as part, because of the time frame of being 2.5 years, we think it's appropriate? Would that help the motion at all or not?
It'll be part of this record.
Okay.
The motion
should say neutral on that, really, because we don't have a real respondents,
I'm going to vote for the motion because I think 2.5 years to find additional information is enough. I'm ready to go. All right, let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Did Ms. Ryan give you all the difficult ones, Ms. Smith?
Excuse me?
Ms. Ryan, did her cherry pick which cases she wanted and give?
Honestly, I'm feeling I think I definitely could.
You're doing a good job.
It's, trial by fire seems to work for me, so.
Okay, number 25.
2015-022-4271. The new information, I'm sorry, this is an additional complaint that has the same it's in the same situation as the prior that we just discussed. It's another complaint by the same complainant. Yeah. And it was also put into litigation monitoring status.
Move to accept council's recommendation.
But they don't have a recommendation.
Oh, I do, I'm sorry. Take the complaint out of litigation monitoring.
It's the commission decides. So the motion is to remove this complaint from litigation monitoring status. Properly made by Ms. Frank, seconded by Ms. Taylor. Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. 26.
2016071541. The new information, council spoke with the licensing division and staff was able to find a record of a conversation between the respondent and the licensing division. The employee who spoke to respondent is no longer employed with the department. The record shows that the employee provided confusing and contradictory information regarding whether respondent needed a license based on the services he told the employee he was offering. After reviewing the contradictory information provided to respondent and speaking with respondent and staff at length, council understands why respondent thought he did not need a license. Council feels that a warning letter setting out the licensing requirements for property management companies is appropriate based on these circumstances. Respondent has assured council that respondent will comply with any instructions and requirements deemed appropriate by the commission, and has further stated that he will be applying for a firm license soon. Respondent has not been offering and will not offer any services that require a license until the appropriate license is obtained. So therefore, my recommendation of warning.
Move to accept council's recommendation.
All right, Ms. Franks makes a motion to accept council's recommendation. Ms. Taylor seconds it. Discussion.
Was this person involved in unlicensed activity?
This person was, when we first presented it, he had formed an LLC, and prior to forming it, he contacted his attorney to ask if the services his LLC would be providing would require a real estate license. The attorney told him, I can't interpret that statute for you because the broker statute is not working on property management, and that's what he wanted to do. And so the attorney said, call the licensing division here at the department. He called and spoke with the employee who's no longer here. And when I presented it last time, we didn't have any proof of the conversation. And since then, I was able to obtain proof that it did happen and that the complainant was telling the truth. I'm sorry, the respondent was telling the truth. And when I read the notes from what the employee told him, it said that it basically quoted the statute of what a broker, if the broker is doing certain things, it means he would do a real estate license, and then right underneath it said, if you are doing these services, you don't need a license. So just very confusing. I would have thought the same thing if I was this respondent.
Is the person doing unlicensed activity right now?
No, sir.
They're not doing anything?
No, he's waiting. He always wanted to eventually get his license. He's got a partner who has already applied for her broker license, and he was just waiting for the instructions. I've been in communication with him.
If they were out there doing it right now, I was going to say, you got to get your license within X number of days, but if they're just sitting, it's fine.
Okay, the motion is to accept council's recommendation. If you're in favor of that motion, vote aye. Aye. If you're opposed, vote no. The motion passes unanimously. Anything else, Erica?
No, sir.
Much better every month.
Thank you. I added the rationale statement.
Thank you.
Was that helpful?
Yes, yeah, absolutely. All right, Ms. Matthews, anything else from legal? Mr. Bloom?
Yes, I'd like Erica to circle on the calendar this date, because you'll never get Bobby to agree to that again.
I will be definitely thinking about it for a long time. It's very motivating.
I think in this time of transition that our staff is to be very well commended for the work that they're doing, and I appreciate that very much. We come and go once a month and come back in and just check it. Right now it's very good, and I appreciate the work you're doing in our absence.
We're going to take that as the first comment. Do you have anything else you want to say?
No, sir.
Okay, Mr. Horn, Pastor Horn. So, wait, I'm going to ask you something.
Yes, sir.
So I'm aware of a 10-year anniversary. I don't think it's been discussed today, has it?
No, it hasn't.
Would you mind telling us what it is?
Well, our church was in existence for 10 years, and they came for a while to wish me well. We had 2 services, and they spent their time, their presence, and told a lot of good stories, and gave me a little money.
That's what I want to talk about. Well, congratulations. Now, back to the real estate commission job. Any comments on the way out of town?
No, I'm thinking that everybody did a good job, and only one person was sleeping. I'm going to tell you like I used to tell people in the military, don't let me wake up and get you sleep.
All right, Fontaine.
I also want to commend staff on doing, a lot of you are brand new, and you really have your feet put to the fire right here, and you're doing a great job, and we appreciate it.
Thank you.
Rick.
I would just like to echo that. You guys are doing a wonderful job. I love being here every month. I look forward to coming up here. I learn something every time I come.
All right, Bobby, you hard.
Apparently I've said way too much today. No, but I'm appreciative of what y'all are having to do in the situation that you're in right now, and we're really not missing a beat right now, and that's because of the staff that we have right now. And then I look at my time, anything I've ever done in any of my career, whether it be working in a realtor organization, and then I always want to try. When I leave, my term is over, I want to leave it better than when I got there. And I still look at things that maybe we can do to get better, and one of those things is, continue to upgrade the staff, and I think we're going there, but as an organization, we got to do things to make sure these people want to stay, but I still got more time here.
So you do. Marcia.
I want to specifically thank Melissa and Sherry and Sarah. They're the 3 that are carrying the huge load in the absence of an executive director. They're all having to do more than they were doing. And they're all reporting. Things are going well in the office. The atmosphere is good. And that's great. And it comes from the three of you, your leadership in that office. And I really appreciate it because you're all going above and beyond. And we really are thankful that y'all are in place. Thank you.
Oh, thank you all. And then when we saw Aaron getting on the aisles, and I appreciate everybody. So thank you.
So, Liza, there have never been so many compliments toward the staff. So just like me, that's the only time you'll ever hear Bobby.
No, I'm sour puss or something, I'll tell you.
I think it'll encourage you to do it every month.
I hope it does. But we're glad you're on board. So we're glad you got to sit in. Wake Forest, I don't know much about Wake Forest. Is it any kind of school at all?
So I was going to ask earlier, is that an accredited university? Accredited or not?
And I also wanted to thank the lady back here in the green shirt because she's here to learn, not because she has to be. So I appreciate her being here.
Well, we're glad you're here, for sure. And thank you, Sherry. By the way, Sherry, in one step of extra effort, went back and reprinted this data sheet during lunch break, so those of you who want to have an updated and correct data sheet, she has it for you, and it's on your desk. All right, when do we meet next? Sometime in August.
We meet in August. I don't have the date in front of me. But Mark did want me to tell you, and I know you all want to know, Dennis has been transferred from Kuwait to Afghanistan. So we found out this morning. So.
But good or bad?
He didn't want to go to Afghanistan when he left because he said it's obviously more dangerous there. So just extra thoughts for Dennis. So.
Put him on the list. How much longer is he?
Is it the same one? Did they change his length of time?
We don't know if they've changed his time frame, but I want to say he still has another 3 months, because I think it was over 6 months, almost 7 total, so.
Else?
I have one more question.
Yes, ma'am.
The consent agenda, do you have comments on, are we doing that okay? We should put anything that we recommend dismissal on the consent agenda and you guys will pull it off? Because I had actually put some of the dismissals that I thought were on the fence that you might not agree with me on the legal report. And Mariana was like, no, let's put them all on the consent agenda. So I just wanted your opinion on that.
Use your own judgment about it.
Okay.
You're here and you hear us and what we're concerned about. That'll help you judge it.
We'll review them, and if there's a question, we'll pull them off.
Okay.
Okay.
Thank you.
I think August 9th.
I think that's right.
All right, ladies and gentlemen, travel safe. Have a good month. Where's it? Travel safely.
Safe travels.
Safe travel.
On the road again. If we're talking about speed.
I am. I'm going to try. I'm going to see if I can do that one trip in 5 hours.
Man, you be careful, too.